directly on this matter, she denied us to do this. Now after the revision and number 954, Musa. Upgraded Musa.
I am mentioning for one upgrade better.
Maybe on next week.
I am mentioning on this.
Yes.
May I be permitted to mention a matter for upgradation? Well, it's a very senior citizens application, Malad. The pleadings are complete. My mutation is not being completed by the respondent, Malad.
Hearing matter.
It is a hearing matter, but Malad, she's 90 years old, Malad.
Give the
After
number.
this,
Give the number.
but it's item number 1176, Malad.
Give the number.
Malad, may I have lordships kindly to mention a matter? Malad, the urgency is that Malad, I am holding Malad the brief for leave, Malad. I run a tea estate. Malad, they have project, Malad, initiated a project called Rasta Street. Now, Malad, through my Malad tea garden, Malad, they are constructing a road. Malad, the cultivation has been destroyed.
Leave will not be granted. File and come back. Give the
Malad,
number.
leave, Malad, so that it can appear tomorrow.
Leave cannot be granted. File and come back. Give the number. I'll consider.
Malad, please, Malad, then Malad.
Yes.
At top, Malad, tomorrow, Malad.
Give the number. File
Not-
and give the number.
Upgradation are mentioning for extension of interim.
Give the number.
My lord, I am praying for extensions of upgradation. I am praying for upgradation.
For the reason,
That mining lease has been will be expired during the lockdown period. So I wanted to extend that.
give the number.
Your Lordship, may
mention two upgradations, my lord.
Why?
This is regarding the 24 Pargana South.
Konta. Owner. In.
Now, my lord, my biggest cultural land, my lord, has been utilized by the respondent as a very.
Give the number. Let me see.
Your Lordship, may I be permitted?
My lord, two similar matters, item number 584 and 648 of the monthly list, they are relating to my lord illegal land structure.
Give the number.
My lord, may I
Lordship, may I be permitted to
mention my
mention?
lord? Yes.
Your Lordship,
877 blockade. He increase his blockade to my dwelling house.
Give the number.
Your Lordship, may I be permitted to mention that I applied for a plot of land under the HITCO and I was allotted, but later on it was my application was cancelled. Your Lordship, now they have issued new notification to issue the.
May I have Malad kindly Malad to mention a matter, Malad, which is appearing as your lordship in the monthly combined list of your lordship as 109, item number 1091. Very short matter, Malad. My land was taken acquired, Malad, by the state, Malad, under the National Highways Act, Malad. The property has been taken. Only the issue, Malad, the matter has not been referred to arbitration for compensation because the compensation.
My lord, my lord, my lord, may I be permitted to mention one matter, my lord, for correction, my lord?
Give the number. To be mentioned, correction.
Item number 42 of your lordship list, Malad, students list. Kindly to the-
Please do not mention supplementary list matters.
May I be permitted?
I am the private respondent. My land has been blocked on the without road.
Service is done. Give.
May I be permitted, your lordship? The Gram Panchayat.
Item number 268, Malad of the monthly.
Yes, what is your urgency?
One of the private respondent have established a so-called zinc, but there is severe vibration and a huge sound, thereby causing damage to the nearby building. There is a crack of the nearby building.
How does this court have determination?
There was a lease deed, the land was allotted with the condition that there will be no commercial activity.
Give the number.
May I be permitted, may I be permitted, your lordship?
Yes, my lord, yesterday I mentioned one matter and my prayer also allowed by your lord. Still, my lord, matter is not appearing in the list. That
Is
is
it a
why,
new motion?
yes, my lord, new motion.
It will appear tomorrow. It will
Tomorrow.
appear tomorrow.
May I permit it for a mention, my lord?
It will appear tomorrow. New motions.
No, matter is already appearing in the list, combined list.
23. It will appear tomorrow. It will appear in the first slot tomorrow.
May I permit it for a mention, my lord?
Mondays, Wednesdays, and Fridays, new motions are taken up first. So as this is a new motion, it will be taken up tomorrow.
My lord, it is appearing in the list of the combined list
Yes,
750.
doesn't matter. Doesn't matter. It will appear. Number টা আছে তো শান্তনু? It will appear tomorrow.
May I permit it for a mention, my lord? One matter, my lord, is running in the monthly list 525. My lord, without acquire my land,
PW2 land road will be constructed. That's why, my lord, on the basis of the urgency mentioned, my lord also fixed till 18 May 2023. Subsequently, it was not hard. My list has been gone. Kindly, my lord.
They are permitted to mention. Gram Panchayat authority to undertake construction in
Give the number, give the number.
My lord, maybe I want to mention. My lord, this mentioning
This is
for-
the last mentioning that I'll take up
My
today.
lord,
Yes.
mentioning for upgradation, my lord, the private respondent obstruct the ingress and egress of.
Give the number, give the
My
number.
lord, my last man.
For
my-
obstruction, my lord.
This is, my lord, my problem. My lord, this is 2018 matter, my lord. I am praying for upgradation, my lord. My lord, already one order passed by Honorable Justice Harish Tandon, my lord. That time it will come under the 4 orders, my lord. But I have served all the copies to all the respondent at the state respondent, my lord. I have served, my lord. Well, I am still, this case is pending, my lord. I am not getting any benefit, government benefit or relief,
It's
my
a
lord.
hearing matter.
My lord, this is 4 orders. It was listed at the time of today.
Forget about that. Forget about that. Now, is it a hearing matter or a motion?
Well,
matter?
both party had not been appeared, my lord. But I have first one
Give the
time.
number, let me
My
see.
lord,
Give the
my
number.
lord.
For up.
Private respondent making construction on, on, give the number, give the number,
Same matter, my lord.
give the number. Yes, call the case, please.
At number 1.
It's for extension of interim order.
Yes. So,
Respondents, you're a
I am happy for the respondent number 6.
private respondent.
Private respondent.
State, Mr. Madhupata. Hearing matter.
Yes, my lord, in earlier occasion, 5 times your lordship explained the interim order, and last occasion your lordship fixed the matter.
if your
for
lordship
hearing.
has this matter on merit,
for
then I
hearing.
can demonstrate my argument. And if your
And
lordship
in
has this
earlier
matter on merit.
also, my lord, I submit my notification as your record by your lordship, and also my lord, one judgment in favor of me. That
What
was
is under
also deposited.
State highway, my lord.
State highway is-
Yes,
Whether the land in question.
Only one for your
governed by state highway authority or unauthorized documents. And my lord, I submitted before your lordship one judgment, my lord, delivered by this honorable high court. And my learned friend in earlier occasion, my lord, 6 time to produce one Supreme Court judgment. My lord,
No.
my lord, my learned junior.
I tell lordship.
Right,
And if your lordship wants to hear this matter, then I can demonstrate my argument. First of all, the power of the authority under section 10(3) has been challenged in the connected rate petition.
Yes.
Now, the definition of the highway authority, you also kindly look into the definition of the highway authority. What is the definition of the highway
It
authority?
is appearing as to be mentioned. Let it appear as a hearing matter. Please be ready on the next occasion. When will you come back?
But
I
everything
will also
is
convenient. I
ready.
will also convenient.
Is ready.
Well, 3rd July,
3rd July. My
first day
lord,
of the, sorry, 3rd July will be a monthly list day. So let it be 5th July,
5th
Wednesday, hearing. Please be ready. I'll hear of the matter.
my lord, 5th July, my lord, kindly, my lord.
And let it be extended till 31st July because every time it is being extended.
My lord, 5th July, my lord, kindly, my lord, fixed as a, my lord, hearing matter as
Yes,
your
yes,
lordship, my
exactly.
lord,
Absolutely.
inconvenient,
Yes,
my lord,
yes.
because, my lord, as per, my lord, my instruction, my lord, the petitioner has no case, my lord, at all.
Heard
My lord,
learned
this time.
counsels for the parties. Paragraph, the matter is ready for hearing. Affidavits are exchanged.
Yes.
My lord, already, my lord, addition of party, my lord, I state as a party.
Let the matter appear under the heading Group 1 hearing on 5th July 2021. Paragraph, the interim order granted earlier is extended till 31st July or on it further orders, whichever is earlier.
That
5th July, একটু উপরের দিকে রাখুন তো। Hearing matter. Yes, next.
Item number 2.
Lord, item number 2, my lord, I am for the petitioner, my lord, like my learned friend is for the, my lord,
Yes.
railway.
Extension of interim order.
Yes.
My lord, your lordship can dispose of this matter as because my lord, your lordship direction was there
file a representation and that representation will be considered by the authority in the presence of his my lord. But order was passed, my lord, without intimating him, without informing him and without the absence of that.
Oh,
The lordship will see the order, the lordship's order.
Last page, my lord, page 62. My lord's order. My lord's order is page 48.
page 50 is your representation, isn't it?
My lord.
After that, my lord, last page is the order of the without giving him notification, without.
So shall I,
Dear lordship, pass, my lord.
an order for
Let the matter be interim order be extended, my lord. My lord, kindly fix.
you are for the railways?
Mr. A.K.
Railways.
is appearing on behalf of the head of India, my lord, in this matter. He could not come due to posted gland operation, my lord. So we will submit in them.
Because
My
the
lord,
previous is the
My
answer.
lord, a short direction may be given for filing affidavits so that my lord.
Not necessary at all. Why?
My lord, as your lordship, my lord.
At the motion stage itself, no affidavits required.
My lord. हाँ दिए तो बोलिए
Heard learned counsels for the parties. Let the matter appear under the heading Group 1 motion on. It's a very short matter, 27 June. 27 June. Paragraph, the interim order granted earlier is extended till 30th June or until further orders, comma, whichever is earlier. It can be disposed of in a day.
My lord. এই একটা xerox করে দাদাকে দিই।
At number 3, my lord, I am for the petitioner. My lord,
The content.
the petition was filed by paying compensation since the land has been acquired by the authority concerned, my lord. My lord, the authority concerned estimated the amount of rupees 9,12,000, but payment has been made only 2,98,000. My lord, the authority concerned filed compliance report, my lord, where from it appears that they have paid only 2,98,000, my lord. My lord, I have filed exception to that compliance report, my lord. Kindly come to page 10 of my exception, my lord. My lord, it is their estimate. Page 10 of my exception filed by the petitioner. না না exception টা আমরা ফাইল করেছি all of
Page
the
8 of the exception.
10 my lord,
Yes.
all officers have signed in this estimate, my lord, and prayed for release of funds, but fact is remained that the amount has been paid, my lord, only 2,98,000. Rest amount not yet been paid.
Yes, Mr. De. This is your calculation.
Yes, my lord, your lordship will see my rejoinder. Affidavit of rejoinder I filed, my lord. My lord. Paragraph 4, my lord.
Paragraph 4.
Yes, my lord. Starts from paragraph 4. Okay.
Yes.
Needless to mention here that in persons of order dated August 2021, passed by the.
Please take the microphone, Mr. De.
In affidavit in opposition, my lord, has been filed on behalf of the state respondent, wherein paragraph 5E and F, it has been mentioned that an estimate of probable case of the Land Acquisition Act under Act 1 of 1894 was made
and the requiring body informed to place the fund of ATO for payment of compensation by number ATO, and subsequently revised estimates was also sent to the requiring body dated ATO and ATO. Said estimate was for the total acquisition land of 17.14 acres in the particular of LA case number 48 ATO. Paragraph 5, subsequently by an order dated 22nd September 2021, Honorable High Court passed order, the relevant portion of the said order is ATO. The state respondent submit that though requisition the fund has been sent to the requiring body, such fund has not been placed by the respondent number 7 before the state authority. After hearing the learned counsel for the parties and considering the materials on record, the writ petition is disposed of with the direction of the requiring body to place necessary funds before the state authority for disbursement of the case within a period of 3 months from the date of communication of this order. This state respondent should disburse the said compensation in favor of the petitioner within a month thereof. Paragraph 6, my lord. That is the fact that by memo number ATO dated ATO, special land acquisition officer Bardhaman, an estimate was placed rupees that it was sent to the executive engineer. That is my lord, that is his exception.
My lord, page 4, second paragraph.
1 মিনিট দাঁড়াও না, আমি বলে নি, তারপরে তুমি অনেক বলতে পারবে। এখন তো সবে শুরু করলাম, তারপরে তো তোমাকে ছেড়ে দেবো, তুমি সারাদিন বলবে তোমার যত কিছু বলার। আমি একটু বলে নি। That is, my lord, paragraph 6 is that is estimate 10, page 10. That it is a fact that by memo number ATO, Purbo Bardhaman, an estimate of rupees 9,12,294 was sent to the executive engineer, Right Bank Irrigation Division, in response to this request made by ATO. It is worthy to mention here that the said estimate was not vetted by the department and not final. It was only a tentative estimate at this office, was under and bona fide impression that to comply with direction of the Honorable Court and also to keep the timeline as directed by the Honorable Court, tentative fund should be ensured from the requiring body right back. 7, my lord. Subsequently, by memo number ATO, dated ATO, addition district magistrate Purbo Bardhaman, the above estimate, which was prepared under the right of fair compensation at that this, my lord, is right of fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 in respect of WPA 5392 of 2021 related to LA case number 48/77 was sent to the joint secretary L and LR department, now waiting for the approval. The said memo was sent. Now, my lord, paragraph 8. That is in response to the above memo, sending estimate, the joint secretary L and LR department is directed by memo number ATO to recast the estimate in the light of the order passed in this case, as the estimate under Act of 20 is not applicable in this case. My lord, that is in the thinking that it is the Act 13, that estimate was there. But in this order, my lord, this is as per this order, the 23 February 2021, that was not applicable, my lord, in this. For that reason, my lord, that is recast in this matter. As directed by the administrative department, the additional district magistrate Purbo Bardhaman by memo number ATO fresh estimate up to rupees 31st December 2013 was forwarded to the joint secretary LR department, and subsequently additional estimate was prepared and additional area by ATO and ATO by memo number ATO. After 10, my lord, after receiving vetted estimate from the L and LR and RR department, that is number ATO amounting to rupees 2,83,450 and vetted subsequent additional estimate of rupees ATO from the LR department, my lord, total amounting to the requiring body has been communicated by ATO and for placement of vetted fund. Also in response to the letter to the bearing number ATO dated ATO, Executive Engineer, Right Bank Irrigation Department, the additional district magistrate Purbo Bardhaman informed him categorically that earlier estimate of rupees ATO has been revised into ATO as per vetting received from the L and LR department. Dated ATO is enclosed here in reference to the subsequently reminder also to the executive engineer of the ATO in para 4 of the between exception of the petition method about 10 money of the petition rupees ATO. That is my lord, that is the position of the case, my lord. As my lord, previous order was thinking that is the Act of 13, that is the 9,12,294. But as per order of your lordship's order, my lord, we are waiting after that, my lord, that is not applicable in this case. For that is, my lord, this order, that is the 2 lakhs 39,000, 2 lakhs
It is
was
finally
estimated.
3,09,000.
Yes, my lord, and that was paid to my learned friend, my lord.
You have received this amount,
Yes, ma'am.
3,09,283.
Yes,
They have given an explanation, sir.
explanation, but my land has been acquired in the year 2013 after the
If you are aggrieved by
implementation.
the compensation, you have to take necessary steps. In the present writ petition, you said that compensation was not being
My
paid.
lord, it is their estimate. They have intimate to me, my lord, that you are entitled to get such amount.
Where is that
Now they-
intimation?
That is, my lord, page 10.
Page
I
10,
have
page
clarified
10,
that,
they
my
have,
lord.
page 10, they have intimated to me, my lord.
That is, my lord,
You
page
are
10,
entitled to
9 lakh
get this
12,000.
amount. Now they are saying, my lord, that
Was page 10 intimated to the petitioner?
Yes, my lord. Everybody has, because, my lord, when the estimate was there, my lord, we have asked the money to the, from the requiring body. It was,
Professor, there is the second intimation to the petitioner that he is entitled to 3 lakhs.
no, no, nothing.
that is the, my lord, after
No,
your
no, no,
lordship.
not,
After your
not, sir.
lordship's order, my lord, or I send the money to him, my lord.
Only in compliance report, they have enclosed that document, but
And you
not
have
sub,
actually received the amount.
that amount I have received. But
If you are
But
aggrieved by
my
the amount,
land has been acquired, my lord, after the implementation of the, after coming to force of the right to fair compensation transfer act,
you have a separate cause of action. In a
2013.
contempt application, that cannot be decided. They have given proper explanation, so this has to be dropped.
My respectful submission, Your Lordship, this is not, my lord, fair explanation, my lord. My lord, because they are officers of the government authority estimate the
They
amount
say this is a
and
tentative
and
estimate.
intimate to me that you are entitled to such amount. And now they are saying you are not entitled.
They have given proper explanation to that. Only thing this should have been communicated to the petitioner also.
Not communicated at
The explanation.
My lord, after that, my lord, I have already handed over the same, my lord, to the,
no,
in this, my lord.
Rejoinder has been
Everything was sent to the, in the rejoinder, my lord. Only
But
for that is,
before-
my lord,
before
I
payment-
filed the rejoinder.
before
As
payment.
because,
No,
my lord,
no,
my learned friend can take
before
recourse of.
payment, my lord, no notice issued. No,
If you are aggrieved by the quantum of compensation, you have a separate forum to deal with it. So in a contempt application, I'm sorry, nothing can be done, isn't it? They've given proper explanation. Heard learned counsels for the parties. The petitioner filed the contempt application for non-compliance of the order of this court passed on September 22, 2021 by the alleged contemner. Stop. It is submitted on behalf of the petitioner that though the petitioner was served notice to the effect that compensation to the tune of rupees 912294 was estimated by the authority comma. The petitioner received only an amount of rupees 3,09,283 as compensation. Stop. The remaining amount has not been paid till date. Paragraph. Learned counsel for the alleged contemner submits that the estimate sent to the petitioner was only a tentative estimate which was not vetted by the Joint Secretary, Land and Land Reforms and Refugee Relief and Rehabilitation Department, comma, Government of West Bengal. The estimate was recast after vetting and the amount of compensation arrived at and the amount of the compensation arrived at amount of the and the compensation arrived at amounting to rupees 3,09,283 was disbursed in favor of the petitioner. Stop. Paragraph. In my considered view, comma, the explanation given by the alleged contemner with regard to variation in the initial estimate and the amount of compensation paid to the petitioner being satisfactory, comma, the order under contempt has been substantially complied with. Paragraph. In view of the same, the contempt application being such and such is disposed of. Paragraph. There shall however be no otherwise recourse, urgency for
Liberty be given to challenge the revised
It's the law. Act line add করুন।
Otherwise, they will say, my lord, contempt.
Substantially complied with বললাম ওখানে however paragraph করে the petitioner is at liberty to however, in the event the petitioner is aggrieved by the compensation paid to him, comma, he is at liberty to take necessary steps before the appropriate forum. Disposed of. Next.
Group 8 motion, item number 4.
Very short matter. There is a
What is the
vacancy.
urgency first?
Urgency is, my lord, if you lost it not entertain, my lord, the third party right will be accrued.
By Monday?
By Monday, it's even today also, it may be.
Lordship, I am praying for adjournment on behalf of Sonal Sinha. So he is appearing for Food and Supplies Department.
না prayer করতে দিবি না
She is severely suffering from cough and cold. So I am praying 1 week adjournment on her behalf.
Point is, there is a vacancy for declaration for dealership. Two criteria are there. One, the person who will be appointing has not in employment, and another is the go down of the dealership would be on a land prescribed pass to commercial business. Our grievance is the person who has been selected. My application is there. According to me, I am fulfilling all the criteria. Who has been selected, he is an employee of the Panchayat. So first criteria he cannot be. Second is the land which has been offered is a billion land, not the Bastu, not the commercial. On these two grounds, he cannot be appointed. We made an representation before the authorities. Up till now, appointment made, dealership has not been handed over. My prayer would be, let my application for may be considered till such time no dealership will be given to the person selected. I am giving to your lordship the.
Let me fix it on Monday.
In the meantime, let them know.
Just one working day. I do not think anything will happen.
If it is appointed, he is given the dealership. My preacher will be fructuous.
Lordship, kindly fix it on Monday.
I'm showing to lordship, my lord, private.
You are the advocate on record?
No, Lordship. I have been instructed by her clerk.
Otherwise, I will not travel, lordship.
There is a private respondent also.
Yes.
Who is not appearing.
Who is not appearing.
So, Mr. Basu, it cannot be taken up like
May I show to your lordship the private case? Your lordship can pass ex parte order if I am satisfied. Your lord.
Monday. I don't think that you any.
My lord, if my landed friend assure my lord, I have no case.
Please give necessary instructions to your client that nothing shall happen by Monday. Yes.
Is it possible
from the bar?
In that event, is it possible to take it on Tuesday? Thursday, Monday, I will be in there. I always candid. It's up to my lord's hand.
Affidavit of service.
Oh, my lord, next week, my lord, will we again go to that bench?
Yes,
Then, my lord,
that's why next
I will
week.
not be able to get this matter listed.
I'm fixing it up on Tuesday.
Another benches, what are, well, my lord.
I cannot do anything more than that, Mr. Basu. Tomorrow is
Kindly,
the last day.
kindly consider my case and
In absence of all the others?
kindly keep it tomorrow.
No, no, not tomorrow.
Then
I already have a very small list, as you know.
I know.
So I cannot
My
cannot keep it tomorrow.
Let me play, then, madam, let me place my case. This is the
You
document
are appealing for the
admitted.
fifth respondent.
Yes, I have no brief. I've been instructed by her clerk to.
State respondent, my lord.
My case is
Food and
admitted.
supplies.
Kunal Sinha for
Food
state
and supplies.
No, food and supplies, lordship.
That's the fourth respondent.
He is for the state.
He's for the
He's
state
appearing.
respondent.
She is giving an undertaking that nothing
Yes,
will happen
Lordship.
by Tuesday, so appear before the regular bench on Tuesday.
Madam,
On prayer of the
Tuesday
fourth
will be-
respondent, the matter is adjourned.
May I?
Let the matter appear before the regular bench on Tuesday, Diddy. 13th June. Sorry, Mr.
Can I
Basu.
record the undertaking? Otherwise, I'll be in.
Cannot record that. Why put her into trouble, Mr. Basu?
But otherwise, my client will be suffering.
It's from the bar.
If I can sort your lordship.
From the bar. She says she'll give instructions.
My lord, she is
And
not
this
in
is-
this. She is not in this matter.
This is happening in all
She
the
is holding.
cases.
She is holding some others on others brief. She is not in this matter.
No, lordship,
Are you assured that nothing, no
How
coercive
she can
step will
assure?
happen?
Not in this matter, she has not any right to, my lord, only he prays for time, my lord.
She is
Nothing else.
making all the submissions.
But he has not any right to.
No,
make any
lordship,
submission.
I am only praying for 1 week adjournment on her behalf. I am not doing
He has
anything.
not any right, my
My
lord.
case has been admitted by the respondent. He said that yes, he is the employee of the
Will you come
panchayat.
back tomorrow?
Tomorrow.
Lordship, I've been only instructed that only to take adjournment for 1 week as she is seriously suffering from cough and cold, lordship.
Council is not.
That's it, lordship.
Well, kindly consider, not me. Kindly consider my.
Lordship,
my
I'm
client's
praying
fate.
for that only. She is suffering from cough and cold. That's why I'm praying for 1 week adjournment on her behalf. Otherwise, I have
Can you
admitted
see
that I
the
am
state of
not
my
in this
client?
brief.
State is appearing.
Can you see the state is appearing? Can you see the fate of my client? It's an admitted fact.
সুশমন কাজটা বলো
Admitted
You
fact.
are appearing for? You are appearing
State.
for?
Yes, come.
ওই তো সুশমন এসছে
Take your
Mr.
place.
Shengupta, please give, because the food and supplies is asking for an adjournment. So I will.
supply. I am appealing.
Oh, no.
Saurabh, she said that
Very
she's
good.
asking
Student
for.
supply, Sonal is appearing.
No. This is
তুমি তো স্টেট
this
বলছো
matter.
Yes,
Ananali.
yes.
Yes, I am appearing because I
I'm
am
safe.
appearing for the principal.
File them.
I'm
See,
safe.
see.
Admitted fact, my lord. But
See, see, see.
ঠিক আছে এটা
So what is this confusion about then? What about the private respondent served?
my lord, we have sent by post.
Hey,
But
the
kindly see
student
two
supply.
things. I will not trouble your lordship. Kindly come to,
Mr. Basu, 1 minute.
Sorry.
Confusion
in the meantime, may I place my case so that my lord is satisfied that I have a good case. But kindly come to
the
page
private respondent is served. Are you?
20. Kindly come to page 28.
1 minute, give me a minute. Where are your track reports? This is not how you mention a case, Mr. Basu. Where are the track
Very
reports?
urgent, very urgent matter.
I will
Other
not take it. I will not take it. Where are the track reports?
fact document is not available.
Means,
Not,
what does
not
that
av-
mean?
Not available.
I will not take it. Since service upon the private respondent is not complete, I will take it.
Can I
again.
take it up tomorrow?
No, I will not.
My
Let the
client
matter
will
appear
suffer.
before the regular bench on, you said Tuesday instead of Monday, 13th.
My lord, my
This
client will
is-
suffer. If you lordship, my lord can pass
Your
an
client
expiry
has
order.
chosen to suffer.
If I-
Your
if I
client
can-
has chosen to suffer because the track reports are not there. Sorry, Mr.
can
Basu.
satis- my lord
Next matter,
can
regular
pass an
bench matter,
expiry order.
please. Sorry, Mr. Basu.
My lord can
Next
pass an
matter.
expiry order if I can satisfy my lord.
Give the undertaking.
Next matter.
My lord, your lordship has power to pass an
When
expiry
it is so
order.
urgent, you should have been ready with the track reports.
Loading upload.
My lord, I have been instructed. I don't know this system. My lord, this has not been uploaded.
No. Huh? Service from,
Today is
since
the-
private respondent. बोले
I'll keep it
Yes,
tomorrow. then.
regular bench, no.
But I have a good case. The respondent
Maybe-
admitted my case.
Maybe the regular bench will deal with it. If you want a
of these persons, my lord, I have sold the land, my lord, because as per my averments in the writ petition, I have never sold. My lord, if my lord directs, my lord, this to pass this order in incorporating the deeds on the basis of which, my lord, they have paid. My lord, we will, my lord, consider that, my lord, if we have agreed, we can come back before your lordship by the next writ petition.
Or before the trial court, if you are challenging the deed.
No, we are not challenging the date. My lord, they said that on the basis of these deeds,
Difficulty is that the deeds number has been supplied to the petitioner. He has applied to, before the another register, it was registered for the Gajol, sub-register. He has applied for Malda, same number, another deed come. So, my lord, this discrepancy is cropped up. So, my lord, if the pair of the petitioner is that the order, according to the representation, the order is kept in abeyance. So, if the petitioner seeks that, my lord, that order can be passed
lord,
within 2 weeks from the, my lord, from today.
only, my lord, my prayer is, my lord, by supplying the copy of the deeds, my lord.
They are not bound to supply copy of the deeds to you. They have given you the numbers. You can take certified copies.
You can apply before the.
You have applied before Malda sub-registry office. It is Gajol.
It is Gajol.
You have to apply before Gajol office, isn't it?
My lord, thereafter, my lord, then, my lord, kindly pass that order, my lord, because if they are, my lord, they will be not be prejudiced, my lord, if they can, my lord, because on the basis of that deeds, my lord, they have given
Yes,
the.
so the number of the deeds have been given to you, furnished
My
to
lord, that
you.
is there, my lord, but if they
So
supply, my lord,
when you are able to get certified copies, why will the authority supply copies of deeds to you? The court cannot direct. You have to collect certified
my lord,
copies.
they have, my lord, placed a case on the basis of these deeds, my lord, they have stated.
Are they bound to produce
No,
copies?
not,
to you?
my lord, in a, because they have, my lord, given also notice to me, and they stated in their, my lord, report, that as because you have recorded your name after the proceeding, but my mother's name was there. They cannot deny. My mother's name was there. My lord, so they have given me the notice. My lord, the notice is in the name of my mother. After that, my lord, on the basis of the deed, the payments has been made.
So without wasting further, because even if an order is passed,
My lord,
that will not inure to your favor. Isn't it?
my lord,
So far as we can make out from this.
my lord.
Without wasting further time, why don't you take appropriate steps?
My lord, let the order
Instead
be.
of waiting for the order?
Well,
how will the order help you?
My lord, order impugned, they have not stated anything, my lord. After the hearing took place, my lord, at page 66, my lord, kindly sees. Page 66 is a hearing notice. I have given an elaborate, my lord, representation before them and demand for justice. After that, my lord, the hearing was taken place. Page 66.
And no order has been passed.
No order has been
That is only during the pendency of the discussion, and it would be passed within a period of 2 weeks. My lord, that is, my lord, the paragraph 11 of my report.
And compensation has been paid.
Compensation has been paid to them.
Yes.
Paid to them on the basis of the deeds, my lord, as has been referred to.
Your representation is at page?
My lord, that is at page, my lord, demand for justice, my lord, kindly sees that it starts at page 59. Annexure P8.
Let them pass an order so that you can proceed with that.
My lord.
Yes? Because nothing further can be done by this court.
My lord, they will supply, my
have
lord,
the
page
deed
44, my
numbers
lord,
with-
kindly sees, they have mentioned, page 44.
Yes.
My lord, this Shiv Kumar Shaha and Sheila Devi, who are the, my lord, private respondents hearing. My lord, they have mentioned this, he has purchased the land by deed number 618 dated 2/2/1990. Here they have not made from which my lord, registry office it was registered. The another my lord purchase Shiv Kumar Shaha,
Of the Gajol.
Shaha 22
In the report of ballot, I have
and
clearly stated that.
9/6/2000. These are the two deeds, my lord. And also there is a, my lord, in the report, they have stated some chain deeds, my lord, which they have not stated. That should also be, my lord, reflected in the order itself. My lord, kindly sees.
Let them pass a reasoned order.
Yes, and my lord, kindly, for the last time, my lord, one paragraph 10 of their affidavit, of their report. These two deeds. My lord, the deeds produced by Shiv Kumar Shah and Sheila Devi are genuine. My lord has got it. Genuine. These deeds are the local jurisdiction ADSR Gajol within the lands in question situated according to the compensation was paid to them. And the chain deeds were also compared for consideration of the genuinity of the transfer. This is, my lord, these chain deeds are also not available with the petitioners. The number and anything, nothing has been stated about the chain deeds. What chain deeds, but my name has been, my mother's name has been, my lord, incorporated there, and I have.
You want to file a further representation before the authority? Stating all these facts?
My lord, let them file the order, my lord. If we find, my lord, we will develop.
Very good. The prime exception used by the petitioner to the report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, the primary grievance of the petitioners is that the plots in question originally belonged to the predecessor and interest of the petitioners, upon whose demise the petitioners have acquired title in respect of the same. Stop. The said plots were acquired by the state government, by the state respondents, and compensation paid to the private respondents who have no right, title or interest in respect of the said property. Stop. Pursuant to representations submitted by the petitioners before the concerned authority in this regard, the petitioners were called for a hearing by the authority, and though hearing was concluded, no further communication was made to the petitioners. Stop. The petitioners seek a direction upon the authority to pass a reasoned order with regard to the representations submitted by the petitioners and communicate the same to the petitioners at the earliest. Paragraph, it is submitted on behalf of the state respondents that who has passed the order, who should be directed?
My lord,
It is heard by the, my lord.
additional district magistrate, that is the competent authority. Additional district magistrate.
ADM,
Fourth
LA.
respondent. The fourth respondent be directed to dispose of the representations submitted by the petitioners and communicate the same to the petitioners within 2 weeks? Within 2 weeks from the date of communication of this order.
And my lord, the chain deed numbers,
Paragraph.
my lord, the chain deed numbers.
You will get the deeds, then you will get everything in the deeds.
Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to dispose of the representations submitted by the petitioners by a speaking and reasoned order and communicate such decision to the petitioners within 2 weeks from the date of communication of this order. Communication of this order. 2 weeks from the date of communication of this order. Stop. It is expected that the details of documents referred to by the state respondents in the report in the form of affidavit submitted by them shall be reflected in the said order.
My lord, that will serve.
Paragraph disposed of, which that should serve your purpose.
Yes, ma'am.
দুটো তিনটে আছে, দুটো আছে। Next.
Number 6.
My lord, in this matter, may I pray for short passover on behalf of Mr. Roy, my lord?
Not possible.
My lord, in that event, my lord, kindly adjourn the matter, my lord. Yes, my lord, that's true, my lord, but
Make your submission.
my lord, I'm not ready in this matter, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear petitioners. Let the matter appear under the same heading on 21st June.
My lord, grateful, my lord.
Please be ready on the next.
Yes, my lord.
Number 7.
My lord, I am praying for not today, only not today. Mr. Pancha, I am on behalf of Mr. Panchanan Hajda, is not well.
Last 3 occasions, they have taken time, my lord.
Please be ready on the next occasion.
I am not advocate on record, he request me.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 5th July.
Yes, thank you.
At number 8. Number 8.
Anyone for the petitioner? Item number 8, anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Dismissed for default.
Number 9.
Subject to correction 9 to 12 and as well as 19 to 39 are similar matters. my lord.
So in 23, my lord, I am appearing.
I am appearing in item number 26.
9,
My lord, I am there in 9.
first matter.
Yes.
No, my lord,
You are the petitioner in all the matters?
yes. No, my lord, kindly take it up, because I am ready with this item number 12. Item number 9, anyway, my lord, the facts is the similar, my lord. Now, what happened, my lord?
Is everyone there?
Proceeding, my lord, in
The
connection,
respondents are there?
yes, my lord. Union of India is there, and my lord,
I am for union.
and the Metro Railway is there.
Union of the Metro Rail.
Yes, ma'am.
Yes, Metro Railway.
Yes.
Now, my lord, for a short fund involved in this, my lord, that initially, my lord, under the, in view of section 105 of the Act of 2013, Metro Railways Act was outside for the purview of this 2013 Act, view of the 4th schedule. Now, subsequently, this was incorporated in the schedule, my lord. Now, my lord, in terms of the circular, that I am entitled to have that benefit pertinent to the determination of compensation as well as the interest. Now, the similar matter I am arguing before your lordship, and my lord, the Metro Railway is about to reply. Yesterday the matter was there, but will not be taken up. A similar point involved is there. Now, my lord, here, my lord, I was allowed, my lord, the compensation. And I was allowed the additional compensation in terms of subsection 3 of section 30, my lord, 12% on the market value. Now, my lord, admittedly, my lord,
possession was taken over prior to declaration of the determination of compensation. Now, my lord, in terms of section 80, I am entitled to have the interest from the date of taking over possession till the date of award. In terms of section 80. My lord, I cited before your lordship, starting from Sundar to your lordship, that wherein the Supreme Court has categorically held that awarding interest under section 80 or section 34 is not the discretion of the court. It's an arithmetical calculation. It is immaterial as to whether I have paid or not. If I can prove that possession was taken over, then my lord, award is to be inserted. My lord, that has been denied by both the competent authority and the as well as the authority. My lord, as of today, my lord, what I am on is this, my lord, that in those matters I have categorically pleaded when the possession was taken over. Here also, because same notification, same acquisition proceeding, entirety. Now, my lord, a project is also the same. This is from the New Korea to Damdam Airport. The metro. Now, my lord, as of date, my lord, what I am praying with your lordship, my lord, that I like to use a supplementary affidavit indicating that when the possession was taken over, because other matters I have indicated.
Here it is not, they're not stated.
That is lacking. So, my lord, that is my humble
But
fear.
you are on the 9% interest under section 80.
89% for the 1 year and subsequent to the 15%.
15%
Whatever
for the-
entitlement is there, because your lordship already seized over the matter. I have completed my argument in the other matter also. Well, yesterday the matter was supposed to taken up by your lordship, but your lordship for want of time could not be, because of the resolution your lordship could not taken up. So, my lord, what I am as of date, possibly my learned friends will not object to this, because I would like to use a supplementary affidavit.
The other matter is a hearing matter.
Hearing matter. My lord, two matters are appearing before your lordship, my lord. One in the monthly list and one in the supplementary list.
I am in item number 11. Look, this is the in admission stage. No affidavits have been filed.
No, not necessary also, I feel,
Yes,
at
it's
the
a
moment.
good-
And the
See,
point
question
that-
of-
point that we have to bring out, because there are a lot of suppression material fact, my lord, that has to be brought before the.
Now, what are the, will your lordship, my learned friend be kind enough, what is the
I'll come to
suppression?
when he
When
mentioned the
the-
entire submission, because things are there, when the affiliate authority has set out, they did not find any records in regard to that. They, even in the damages they asked for, there are also no
That
records.
is not the subject matter of the, I am not paid for that in here.
In a troubled water, my lord. What they have come out in 2019, they make out an RTI where they ask out the question whether the implementation of the entire project has been done or not. So obviously the project started in 16. Can they come out with that? Saying that our lands were taken
The
for this?
petition revolves around a very small issue.
My lord, that issue I'm saying, because 80 when it says with
They are
possession,
claiming
we never
interest.
took out the possession before 2019, my lord. In November 2019, we took out the possession. And the amount was already been deposited after the affiliate authority had passed on the order, my lord. Now, thing is there, now he's coming to the 2016 matter that the possession, the men's of railway may have come, the apprehension is there. Even one Lily Homes, which in item number 12 that has come out, my lord, in that also, he has been using that word, the petitioner has been using, that they have been determined, but that was never been done. On anticipation, the appellate authority has clearly and categorically said out, on anticipation, I cannot go into that matter. Because that the anticipation was made.
Let him come
Let
back
the
with a
petitioner
supplementary-
say first,
supplementary
and
affidavit.
then
In the meantime, do you intend to use a report
Yes.
in the form of an affidavit that can be
Right,
done?
kindly takes up subsection 3 of section 105.
Shantanu.
Subsection 3 of section 105 of the fair.
Right to fair compensation.
আমি দিচ্ছি।
সব একসাথে করে
এটা
দিয়েছে,
যশোর
এরকম ভাবে হয়। Right to fair compensation. সব আমি আলাদা করে রেখেছিলাম।
শান্তনু, এটা যশোর
ওটা দিয়ে দিন।
দিন এখন আপাতত দিন এটা।
All the books are here, cannot be found.
আচ্ছা, আমার কাছে আছে।
May I read it, my lord?
Yes. 103?
The central government shall
105, my lord.
105 subsection 3. The central government shall, comma, by notification, comma, within 1 year from the date of commencement of this act, comma, direct that any of the provisions of this act relating to the determination of compensation in accordance with the first schedule and rehabilitation and resettlement specified in the second and third schedule being beneficial to the affected families shall apply to the cases of the land acquisition under the enactment specified in the fourth schedule, or shall apply with such exceptions or modifications that do not reduce the compensation or dilute the provisions of this act relating to the compensation or rehabilitation and resettlement as may be specified in the notification, as the case may be. Let him come out with such notification before your lordship produce that notification, which says that the central government has accepted that first, second, and third schedule will also apply to the fifth schedule, fourth schedule. That notification has to be produced before we even go to any factual aspect. This is the law.
My lord, law is something
No,
different. I tell you.
law is this
My
notification.
lord, I tell you, lordship, why? Because this is possibly that cannot be their case. That my compensation has been determined, market value is determined under the 2013 Act or not. Because market value has been determined under 2013 Act. And I was awarded benefit of subsection 3 of section 30. It is recorded in the order sheet. So therefore, that I'm not to produce the circular. Even as I will produce the circular. Because
Circular,
admittedly
no.
the award has been
Notification,
declared,
madam.
award
Award
has
is
been declared. That is notification.
No.
Award has been declared after 2015. After 2015, the award has been declared.
Please come back with a supplementary.
Yes, kindly allow me to
And
supplement.
annex
I will
this-
also annex that.
Annex this
Yes,
judgment
but I will.
documents.
I will.
And in the
Kindly.
meantime, do you intend to use a report in the form of affidavit?
No, there is no notification, my lord. The applicability has not been met. These are, my lord, I will try
Let
to,
him come back.
let him come back, my lord.
Means in the factual aspects also, my lord, there is
Do you want to come back with a
Yes,
report
yes.
My lord, report, if need be, my lord. we'll-
in the form of an affidavit?
Yes.
Because affidavits at the moment is not required, I feel. We can dispose it of at the motion stage.
Well, kindly record my submission with regard to item number 26 in this respect, my lord. My lord, my submission is that, my lord, till now I have not come across any notification under subsection 3
I'm
of our
not
section.
recording anything at the moment. I'll deal with it. Come back with the reports and.
Very surprising. He is representing Union of India and he has not come across the notification. Very
Third
surprising.
learned counsels for the parties. Learned counsel for the petitioner seeks to use a supplementary affidavit
My lord.
annexing relevant documents. Paragraph. On prayer of the respondents, liberty is granted to submit a report in the form of affidavit, comma, if necessary. If you feel you can.
My lord, the Railway Construction of Work 1917 Act is a complete code. And the provision is there, my lord, from the date of notification, Metro has a right to enter into the site. And any interest, if at all entitled, that is from the date of the adjudication by the competent authority and the date fixed. And therefore,
The petitioner is not denying the right. The petitioner only says that he is entitled to interest under section 80 from the date of possession.
And that act,
If you say that the metro has taken over possession from the same date, you are admitting the petitioner's case and he is entitled to compensation.
but this 17 Act is made for the Metro Railways and its
Yes,
properties. But
yes.
therefore, my lord, this act cannot be applicable. And here is complete provisions are contained in this act itself. All the provisions are contained. How the position will be taken, how the interest will accrue, when the payment will be made, to whom the payment
So
will,
you say that
everything
the
is there.
2013 Act is not applicable?
Act is not applicable, my lord. But wrongfully the appellate authority dealt with.
But you have not prepared an appeal against that. That is.
If anything is wrong, you record, my lord, the read court can set aside that.
Without preparing an appeal.
So far as item number 29 is concerned, so far as this claim of interest is concerned, there is a third round of litigation. First two round, approving authority, appellate authority, then
The petitioner wants to come back with a supplementary affidavit with relevant
till date,
documents.
no representation claiming interest. till date. Well, only will not, revisional application was disposed of, thereafter a fresh writ petition has been filed.
Come back after, let us consider, I'll deal with it altogether.
Milord.
And I think it would be better if I deal with it one at a time because your
Yes.
submissions are different, slightly different from each
Yeah.
other. One at a time.
No, my lord, Union of India speaks with one word. Single term. My lord, whatever be the thing, my lord, we cannot change our step. As such, my lord, I had mentioned, my lord, before your lordship that 19 to 29 are similar matter.
When will you come back?
Well, give me 2 weeks time, my lord, I will file my supplementary.
Sir, after 1 week, if we give the supplementary evidence serves upon us, there
Please serve an advance copy so that they can deal with it.
So, my lord, give me 1 week time. Give me 1 week time, my lord, to file my supplementary. I will serve a copy of my land.
6th July?
Fine.
6th July.
Milord.
I will
All
serve-
these matters together?
Fine.
Item same order. Item numbers
9 to 12 and
9 to 12. Yes.
19 to 29.
And 23.
Not 14, 15. It's the same advocate. I
Now,
find.
14, 15.
14, 15.
Yes, 14. देखिए, आपके-
14, 15. I find the same name.
Only, my lord, item number 9 to 12, 14 to 15,
13
and
is it?
19 to 29.
Please repeat.
9 to 12,
Yes.
14 to 15, 14 and
Yes.
15,
Yes.
and 19 to 29.
19 to 29.
19 to 29.
Well,
হ্যাঁ 19 টার সাথে বিট আছে 19 এ একটাই সিঙ্গেল অর্ডার হবে 19 এর সাথে বিট আছে 29 এর এগুলো সিঙ্গেল অর্ডার এগুলো সিঙ্গেল অর্ডার
Milord.
বললেন না 6 জুলাই your book
কত বললো 6 এর কত বললো
হ্যাঁ 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 14 13 টা 13 টা আলাদা
Item number 13.
Lord, I beg to appear for the respondent.
I beg
Previous
to
occasion, my lord, there was a
Five, my lord.
there was a direction.
who is appearing for the petition
I am the petitioner. My lord, on the last occasion, both the opponent parties did file some affidavit, but no copy of affidavit has been served up to me.
no
till
copy has been served
No.
you are filing it today
My lord.
advance copy
My lord, all these are basically judicial orders of this court.
whatever it is you
Very
can
well, my
serve.
lord. I'm serving a copy. I'm serving a.
With regard to my lord, the respondent number 5, which is the port trust, my lord, your
Yes.
lordship had directed to file a report in the form of an affidavit,
Yes.
my lord. I was humbly praying, my lord, if my lord, fortnight's time can be granted, my lord.
Another fortnight the order was passed on 24th April
Yes, my lord. My lord, the possession, my lord, admittedly, my lord, has been taken over by the port trust, my lord. The facts of the case in brief, my lord, port trust had given, my lord, on lease, the Central Warehousing Corporation, which is another public sector undertaking, a portion of the land, my lord. CWC in return had given the writ petitioners the land on sublease, my lord. Thereafter, my lord, CWC got the petitioners evicted, and my lord, CWC has handed over possession to the port trust, my lord. Your lordship was prima facie of the opinion that the writ petition have become infructuous, my lord. But my lord, your lordship had directed us to file a report, short report in the form of affidavit giving the status, my lord.
My lord, the
Humbly
only
praying, my lord, if my lord, fortnight's time can be given, my lord,
the
we'll file it, my
only
lord.
issue in dispute, my lord, was the fact that my learned friend appearing for the petitioner, he opposed to the fact that it has not been vacated. And our submission was that the place, the storage space has been vacated, it has been taken possession of, and it has been given to port trust. Now, your lordship was kind enough to call for the report only to the extent and the fact that whether the possession has been handed up or not.
it has been you say
Yes, my lord, it has been. In
what
fact,
remains in the writ petition
My lord, my lord. My lord already entered in merit on the application on the last occasion and then asked them to file affidavit. And I also pray that my matter will be hard on merit and both of them club together, though the matter may not be hard on merit. My
my
lord,
lord,
it's a
the fact is
and my
another.
submission is that-
I find primarily is for setting aside the order
Yes,
passed by the CWC
yes, 15, no, extra officer of the CWC, the 15 to 20.
15 February yes what is the
20.
15 February order
There was the order of eviction.
page
Al-
15 February order
at page 58 of the writ petition. My submission is that when they are asking for the time of 15 days, 15 days may kindly be granted and allowing me to file the written notes and argument. This matter is become very
Please tell
critical.
me how your writ petition is maintainable first, sir. Please tell me how it is maintainable.
May I argue?
The order has admittedly been complied with,
Yes,
executed.
that may be so. That may, I do not.
Your-
No,
So
no.
now what further remains in your writ petition?
Remains is that I am calling concerned about the illegality of the order challenge. It is subsequent proceedings that I have been evicted by another writ petition, but that does not weaken or disentangling me, my writ petition.
The writ petition becomes redundant, sir.
No, I am showing. What are they?
You have asked for setting aside an order which has already been executed.
No, no, no.
So the order cannot be set aside.
No, no, no. My lord, see, my supplementary affidavit, it went to before on a division bench. He asked this single court, single bench to decide the matter on the merit. Guys, can see the affidavit.
After
Supplementary
it was executed?
Yes. Can you supplementary affidavit?
After it was executed?
Yes, my lord.
Lordship sees the observation of the division bench. It is at page,
Kindly see, I am arguing the matter. At page 9 of the supplementary affidavit.
page 36 of my report.
I am referring supplementary affidavit filed by me, running page 9.
Please give me a minute. Supplementary affidavit, no?
Yes.
Oh, yes. Running page 9.
9.
Yes.
This is kindly see the first page of the page 9. There is WPA number 2428 of 2022. First page of running page 9.
Yes.
This writ petition was preferred by the CWC to vacate the property by policing. There are no stay from any court of the law. And while disposing the writ application, Justice Mantha recorded that this petition is pending and the order passed at least subject to this writ petition. Secondly, this order was gone through by the on division bench and come to the page 11. So the concluding part of the order. In said circumstances, at this stage, no case is made out to interfere in the order of learned single judge. In case the appellant succeeds in the pending writ petition being this number, then it would be open to the writ court to pass approved orders in accordance with law. Even if I be evicted, I can get restored possession. We make it clear that we have not commented upon the majority of the writ petition or on merit of this recent petition, which will be decided by the concerned honorable judge on its own merit, taking into account the facts which may be placed on the court. I have challenged order dated 15 to 20.
I am deciding the writ petition on its own merits.
Yes, my lord.
Which is that the writ petition is redundant.
No.
I'm sorry, sir.
No, my lord, then start from the last order. I'm to file the affidavit which asked before
Not
by
necessary.
them.
Not necessary. I will not grant him further time for affidavit.
No, then my lord, allow me to argue on the entire thing.
No question, sir. No question.
See, I am showing. Take up section 1.
When an order has already
The last
been
order I said.
implemented,
I am showing to judgment of the Honor Supreme Court.
My lord, in any event,
Kindly
my lord, CWC had subleased the property to them. CWC
please
has
show me
handed,
an authority which says that even after implementation, it can be dealt with.
my lord, CWC has handed over it to the port trust, my lord.
Yes, relevant paragraph. Relevant paragraph.
Yes. But these are page 3, that is 194, 5 SCC,
1994 Supreme Court cases.
5.
380.
Kindly come to page 390.
Page
390.
390. Yes.
My lord, in this judgment, it has been discussed whether even after I have been evicted, whether the writ petition is still maintainable. This is discussed in the judgment. That's paragraph 18. In regard to the law of restoration of loss or damage caused pursuant to judicial orders, one of the first and highest duties of all courts is to take care that the act of the court does so no injury to any of the suitors, etc. And when the expression the act of the court is used, it does not mean merely the act, etc. And Madam, come read after the 1820 and relied upon 144 CPC. 144 CPC says that if in order revision and appeal it succeeds,
the possession went back to the party. This 144 says Court of Civil Procedure. And there is another judgment of Division Bench of Gujarat High Court. Gujarat High Court, that is also kindly see paragraph 27.
This is on reversal of a decree.
Yes.
This is a separate cause of action altogether.
No, yes, therefore, it is it does not weaken my case that I have dispossessed.
You have no case. There's no question of weakening, sir. There is
No,
no case at all.
no, my lord, on mistake.
You have already been evicted, so it is a separate cause of action. You can challenge the eviction.
No, cause. This says I preferred the appeal, this dispensation in the form of appeal. If I succeed, I'll get possession back.
Have you preferred an appeal?
This is the, my lord, the statute does not make me bar to file this petition. There are series of judgments that when
I'm
any
sorry,
order
sir.
can be.
I'm extremely sorry.
No, my matter is not heard. My matter is not heard by guest officer. That is the principal natural violated.
So that is the ground of your appeal.
No.
That is the ground of
No,
appeal.
matter is not at all hard
I'm
on
sorry,
merit.
sir. I'm sorry.
Not matter or not at all hard on merit.
Report in the
And-
form
and
of
I kindly
affidavit
follow
submitted
see,
on
kindly
behalf
see.
of the Central Warehousing Corporation, Kolkata Regional Office is taken on record. Paragraph.
I am not at a concern about the destruction.
is
My
the-
order challenge input that is without
It
maintaining
is
the
a
law and
separate
propriety.
cause of action, sir. It's a separate cause of action.
I'm not
The
seeking
writ petition primarily challenges
in restored position.
the
I am only submitting that this does not weaken my case.
order passed by the Estate Officer Central Warehousing Corporation on 15 February 2020. Stop. It is the admitted position that the said order has already been implemented and possession of the warehouse,
Storage space in the warehouse.
possession of the storage space in question has been handed over to the Central Warehousing
To the
Corporation,
Kolkata Port Trust,
the
the respondent
Kolkata
number
Port
5,
Trust.
by the Central Warehousing Corporation.
to the Kolkata Port Trust by the Central Warehousing Corporation. Paragraph, in view of the above, comma, nothing further remains to be adjudicated in the writ petition since the same has become redundant. Paragraph, the writ petition is being WPS such and such is accordingly disposed of. Urgent certified website copy. Sorry, sir, it's a separate. cause of action altogether.
My lord, may I beseech your lordship to kindly record the Port Trust's, my lord, presence, my lord, before your lordship.
Yes, give your name.
Obligation.
Port Trust. Kindly see the judgment.
Yes.
The judgment may kindly be given.
Next.
And number 16.
Yes, petitioner, you're appearing? Anyone for the petitioner? None appears for the petitioners. No
16,
accommodation is sought, dismissed for default.
Chalo, huh? And number 17.
For the state respondents.
Petitioner?
No, I'm for the
Yes.
exception.
Definitely. A report is submitted by the National Highways.
My lord, report has been filed, my lord. My lord, I'm praying for an exception. My lord.
State doesn't intend to file any report. You want to use an exception? After such a long time? March, you received the report. We are in June.
My lord,
No urgency.
no, my lord, there is, my lord.
Nothing.
Learned counsel for the petitioner seeks to use an exception to the report in the form of affidavit submitted on behalf of the National Highways Authority of India. Paragraph, let the matter appear under the same heading on 7 July Please serve an advance copy.
The advance copy may be
Advance
served.
bill.
Lage na response.
Number 18.
18, my lord, I'm praying for an accommodation. My lord, Mr. Shopton, who is reading.
Respondents,
Mr. Rabindranath Datta, Mr. Anand Datta for the state.
is not there today. We've taken several adjournments.
Mr. Bharti is reading. My lord. There have been a few adjournments, my lord. From either side,
Please
my
be
lord.
ready on
From either
the,
side, my lord. For the report, my lord, numerous adjournments were taken.
on prayer of the petitioner, the matter is adjourned. None appears for the respondents, sir. None appears for the respondents. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading. On 10th July.
My lord, I appear on the state respondent.
18.
18.
Previous one.
10 July, madam.
10 July. Join. Owner নামটা দিন মিস্টার।
Arun Datta.
Arun Datta. My lord, extremely grateful, my lord, your words.
30.
Item number 30.
এই তোদের মামলা, এই তোদের মামলা। না না তোদেরই। পার্থপ্রতিম। না অনির্বাণ দাস।
অনির্বাণ দাস মানে আমাদেরই কি পার্থ?
হ্যাঁ পার্থপ্রতিম।
3-0.
হ্যাঁ 3-0.
Yes, where is the report, Mr. De?
My lord, report is not necessary, ma'am.
Not necessary?
Only the last.
Because report
Very
is
well.
not necessary, my lord, as because my lord, the petition is not maintained. Maximum he can pray for consideration, but if this application, that is the consideration is very, he should file a fresh consideration, fresh application before the authority. That is before petition.
শান্তনু, শান্তনু। সেম ডেটে দুটো অর্ডার ভাঁজ করে রাখা আছে। 25 এটা 25
রিপ্রেজেন্টেশন হয়েছে।
ছেড়ে
আগে আমরা আগে
What is the matter about?
বল কি
My lord, my lord.
My lord, after taking possession, my lord, they filed one objection, my lord. And objection was considered by the authority, my lord. That is an for the and that is in the, my lord, that is give notice to the to them, my lord, page 40
Notice was issued to one of the petitioners.
is one of the
Petitioner number
petitioner.
24.
Yes, my lord.
But after that, no communication was made.
According to them, no communication was made, my lord. After that, my lord, that was acquired by the, it was given to the National Highways Authority.
The land has been transferred, my lord. The land has been transferred from the
Has been
state by the
transferred
state
as-
government.
Hearing the
As,
petitioners.
yes, my lord, we have already acquired the land for that reason. That notice was, according to that notice was there, and they, that is according to paragraph 6, my lord. The paragraph 5, your petitioner state that as soon as the respondent authorities took possession, your petitioner made objection to the office of the collector and utilized by the landowner authority. Your petitioner said, considering the said objection, this is to my state directed to appear on 19 January 2015, my lord. But my lord, after that, my lord, they have nothing to say. My lord, after that, my lord, they filed an application, that is on, my lord, that is page 15, my lord. 8th September 2020. Conduct of the petitioner, my lord, after 9/1
My lord,
and admit. And in that, my lord, notice, my lord, nothing was there. We have not given him any order or anything else. My lord, your lordship will see that page 16 and 17, what they are stating in the representation. After a long gap, my lord.
This is a demand of justice.
Yes, my lord. And demand justice, how that demand of justice is written, my lord.
All the petitioners, my lord, they claim they are now the encroachers, my lord.
My lord kindly considers, my lord, my learned senior friend, my lord, of the state.
My lord,
My lord preliminarily submits, my lord, that report is not required, my lord. My lord, our allegation is my lord, no acquisition was done previously. The NH authority, my lord, has for the first time taken possession of my land without paying any compensation. My lord, the counter allegation is, my lord, that the state initially acquired it. The state, my lord, gave it to the NHA, my lord. Nothing has come forward till date, my lord, whether, my lord, when the state.
It's necessary, Mr. De. Report is necessary.
How, my lord, petition is maintainable? As because, my lord, paragraph 5 and 6. Paragraph 5 is that, my lord, your petitioner say as soon as the respondent authority took possession, your petitioner made objection.
Yes.
And that, my lord, objection is 9/1/2015 and asking them to 19th January 2015. There, my lord, after that, nothing was there. After that, a demand of notice was there. Demand of justice is there.
In the year 2020.
My lord, conduct of the petitioner is this.
My lord, if the state, my lord, can, my lord,
If the
satisfy on this point on your lordship, that, my lord, the
My
land
lord,
was
they must
previously
satisfy
acquired. My lord,
19/1/2015. My lord, how they
It is
conduct.
not always that delay defeats the case because it's a recurring cause of action. Position has been taken, they have made communications, no order was given. It is not a one-sided affair. The state also has some responsibility. So please come back with a report showing that you have
My
acquired
lord,
the land.
petitioner has not any responsibility.
My lord, at least the details.
My lord, petitioner must prove his case. My lord, why?
Both
that-
the parties have their
No,
own
my lord, first,
responsibilities.
my lord, petitioner, why that the petition is.
They please come back with your report. It has to be dealt with on merits. Because
But
his case is that the national orders
according
have
to
just
me,
taken
my
away
lord,
the land.
the petition is not maintainable. I must prove
That should be
petition is
recorded,
not
my lord.
maintainable.
That should be recorded, my lord, at the instant lordship that this writ petition is not maintainable. Also, that point
I'll
should be
keep the
kept
issue
in mind.
No,
no,
I'll keep the issue open,
Yes,
maintainability issue, but
That
it should
should
be
be
dealt
kept-
with on merits also.
My lord kindly considers, my lord, this. My lord,
consider
issue is-
করবেন যারা।
my lord, this issue is being agitated, my lord, after the initial order of the report.
Yes.
My lord,
Should be-
in this
should have been
matter,
the
my
preliminary
lord,
issue, my lord.
my lord, in
Should
this
have been
matter, my lord,
preliminary issue, should
your
have
The
been
maintenance
preliminary
lordship
issue.
can be taken at any point, my lord.
my lord, your lordship appointed me in this case, my lord.
Yes.
So first day I can't, it is not possible for me to see the petition.
My lord, let that be kept open, my lord. I cannot object. I'll not
Yes.
object, my lord. Once a report, if a satisfactory report, my lord, comes before your lordship, and dispose it.
তোর purpose to serve হয়ে যাবে, জান না?
Mr. De, you were appointed sometime in 2021.
Yes, ma'am.
After that, several dates. And then in
My lord,
2023, the
my
report
lord,
was called for.
I got the file, my lord. After that, my lord,
After 2 years. Learned counsel for the state respondents. Several extensions have been sought, Mr. De. Please be ready with your report.
Yes, ma'am.
Further extension of time to submit the report in the form of affidavit as called for. Learned counsel also challenges the maintainability of the writ petition on the ground of delay on the part of the petitioner. Paragraph, let the matter appear under the same heading on
Similar nahi, pore-
11th July.
No.
11th
My lord,
July.
11th.
Paragraph, the issue of maintainability is kept open. Kishan. কপিটা কোথায় সেম দেখে নিতে হবে কিন্তু পাঠিয়ে দিন আপনাকে এই কপিটা দিয়ে পাঠিয়ে দিন একবার দেখে নেবো কি আছে নেক্সট
Item 31.
31, my lord, I am for the petition.
I am appearing on behalf of the state, my lord, paid by this.
Yes.
And I have already submitted report, my lord.
Report already submitted.
That issue, my lord, whether Well, the solatium and interest, my lord, those are statutory provisions, or my lord, they were not awarded by the arbitrator, my lord. Whether, my lord, I have to, my lord, approach the for section 34, my lord, similar issue. My lord,
So you're not challenging the order of the arbitrator. You're saying that it has not been complied with, not been implemented.
disburse for the competent authority to disburse the benefits according to the award of the arbitrator, who has, my lord, increased the market value, and, my lord, accordingly the solatium and the interest part, that should also be, my lord, increased accordingly. They are not separate components, and, my lord, no challenge should be made.
My lord, the component is not the part of these proceedings, my lord.
Yes,
This components is not the part of this arbitration proceedings.
component has not been challenged. The amount has not been paid. That is in the arbitral award has not been complied with. That is his case. He is not challenging the award.
My lord, your lordship recently, my lord, in one of the matters, my lord, Mr. Roy was arguing, my lord, your lordship, my lord, decided this point very recently, my lord, prior to the vacation, my lord. May I, my lord, bring that order, my lord, bring your lordship's order, my lord. it will-
The same issue.
Similar circumstances, my lord. Mr. Roy was arguing that matter, my lord, I was assisting him, my lord.
You've taken several adjournments. You should have been ready today.
My lord, my learned friend should satisfy the court lordship. In the year 2016, the arbitration proceeding has been conducted, my lord. In the year 2021, lordship, he prayed this application before your lordship. And in the year 2019, my lord, they made any demand justice, my lord. These lapse, lordship, they should be.
When was the amount paid?
My lord, he annexed. It is
When was
page
it paid?
34.
Page?
P3, my lord, as per my learned friend said, this is a page P3, that is
My
page
2017, I can find, my lord, from
my lord.
my lord, page
51. As per my learned friend's page is page 51, my lord. He
49, 50, my lord, first starts from 48.
This was paid in 2017.
17. My lord, 19, my lord, the representation was.
Why this explanation, my lord? There is nothing in this writ petition, lordship. There is one averment that this delay has been, the explanation of this delay, lordship, has been mentioned in this writ petition, my lord. That should, my learned friend should satisfy your lordship.
The demand of justice is in 2021.
No, my lord. There was a previous demand of justice as well,
2019, my lord.
19.
Every time there's a 2 years gap, right?
There's a previous gap.
And my lord, there is no explanation in this writ petition.
17, 19, 21.
This I cannot improve my case, my lord.
No, but how do you explain?
But my lord, the statutory component, my lord, there's no, my submission would be section 34. In case of section 34, limitation runs. In this case, my lord, it's an integral part of the award. So, my lord,
Section 34 is not applicable.
Not
That is
applicable.
admitted.
it's
So
not
let us
applicable,
put that aside.
my lord.
How do you
Well,
explain the delay?
For this, my lord, this is if it's an integral part of the award, my lord, should have been made into the award. There is no, my lord, the limitation does not run.
No question of limitation. You have to explain the delay in a
There is,
petition.
there is delay, my lord. Well, I'll satisfy. I'll satisfy. I'll try to satisfy. Try and satisfy.
2 years and 2 years. 17, 19, 21.
21.
Read file also.
Every time you have waited for 2 years.
There is a delay.
So what had happened? You had gone abroad.
My lord, rustic village, absolutely, my lord, village. Kindly consider that part.
If you want to use a supplementary affidavit, you can.
My lord.
Let him come back.
My lord.
Let us deal with it on merits.
My lord, my
Lord.
So shall I grant you liberty?
My lord.
On prayer of the petitioners, liberty is granted to use a supplementary affidavit in this matter. Paragraph. Let the matter appear under the same heading on 12th July.
My lord, can be recorded, lordship. They have to explain these delay portions, lordship, in this supplementary. Otherwise, lordship, matter will come on the next date, lordship. They will totally.
No, of course, my lord.
Well, that should be
Supplementary affidavit in this matter explaining the delay in approaching the authority for enhancement of compensation as well as filing the writ petition.
My lord, a bit more time, my lord.
Bit more time.
They are trying to call them from petitioner over, my lord, the number of petitioners.
17th July.
7.
Let the matter appear at the same hearing on 17th July.
number আছে number 32
For the petition in this matter. Here the petitioner's mother was, here the petitioner's mother was the owner of some plot of land. Now initially the property was vested upon the state. Challenging that
So
order,
they are appearing.
yes, ma'am. Challenging that or vesting order, the petitioner preferred a writ petition before the Honorable High Court. High Court set aside the order of vesting and send it back for reconsideration before the BL. BLRO passed an order, fresh order, declared which property they have retained and which has been vested. Now, in that schedule, they have specifically mentioned some properties which you have retained. Now, suddenly, over this particular property, the Public Health Engineering Department fixed a board that this property belongs to them and they are going to start a my lord water project over the property. Now, kindly come to page 33, the order of the BLRO passed pursuant to the order of this Honorable High Court. Page 33, my lord, it's a handwritten order. Order number 15.
Page 33, yes.
Page 33. Order number 15. Shri Kanalal Kaur is found present. Since his presence dated such and such to this matter of this early first disposal of the instant case. His petition dated such and such is filed with the case records. Seen the case record in details, the instant case is long pending one in spite of the court's order for time-bound disposal within 2 months from the date of submission B form in accordance with law. Beside the facts of that, High Court Calcutta issued directives to the respondents to consider the matter afresh and allow the petitioner to retain lands with the ceiling limit and vest the lands if it is found that the petitioner is holding lands beyond the ceiling and taking into consideration the classification of lands on the basis of some incorrect particulars in the B form. The lands is still in possession of the petitioner. The rule is made absolute and the order of vesting annexed is quashed. The case is taken today for final hearing with reference to the above directions the court concerned. The incorrect classification of lands are considered as per Amin's report dated such and such is requested to be taken into account of classification of land as pointed out by his report dated such and such the Amin's concerned. Seen the letter wide memo number such and such of the office addressed to the DLRO Tomluk and the letter wide memo number such and such dated Mednipur the 5/8/1992 of the DLRO Mednipur to this office. These letters amply leads to the fact that the payment of compensation is not till paid to the involved beer concerned. Hence, it is presumed that the desired relief may be given to the writ petitioner as per the court directives. Now, after going through the case record in details, court's order and the other relevant papers, it is ordered that the writ petitioner Indubala Kaur as well as BR is allowed retain land as follows. Thereafter, they have specified which land we have retained and which has been vested in 2 different districts. They will kindly turn to the next page.
But where are the details of the land, the dark number?
I'm coming to that. But kindly come to the page. Then my lord, kindly straightway come to the page 38.
Yes.
This is the schedule of the land which we have retained. In the right hand side, annexed A. And my lord, kindly come to page 41. This is Kalika Fuli Moja. My lord, got it? It's the top of the page, my lord.
Yes.
Kalika Fuli, number 91, Mednipur, dag numbers and all details has been mentioned. Now, over these 2 properties on the Moja of Kalika Fuli, they have started a water project in my land, my lord, without any acquisition, without anything. And it has been clarified by this order of the BLRO, these properties we have retained. We are in possession, we have retained these properties has not been vested. Now, we made a representation also. That is at my lord, page 53, we have specifically clarified this. Page 23, paragraph 23, page 54, where specifically stated that we found a board has been affixed by the public health engineering department that this land is belongs to him. But this is our personal property. As per this order of BLRO, we have retained this property and some properties has been vested. So without any acquisition, without anything, they have started to work over my property.
They have started work already.
Started.
Yes, Mr. Dev.
My lord, that application will be considered by the.
But may I say one thing, my lord? It's a record of 1994. So let them file a report.
My lord, that will be.
Because if your lordship
considered, my
send
lord,
it for consideration,
my
a
lord,
record will not be placed because
lord,
all the authorities have to be incorporated. The PHE, the BLRO, the DM, everything, because land has been handed over by the collector to the PHE. Thereafter, PHE started the work. So entire thing will be very difficult. So let them file a report.
My
But
lord,
how the PHE got this property?
My lord, for that reason, my lord, PHE will consider his application, representation. How they will got this land, my lord? That is the written land, if that is so. My lord, how they will get that land, my lord?
In my humble submission, it will be better if the DM file a report. Because perhaps the collector, from the collector handed over the property to the PHE.
তোমার ল্যান্ডটা লিখেছো কোন প্যারাগ্রাফ?
Paragraph 23 in the representation.
That is in that number, paragraph 14.
No, 23. Page 54.
Page 54.
They have taken possession of the land.
Yes. Only for that reason, my lord, they will consider. Otherwise, my lord, they will come and say.
I have annexed a
how
photograph that
they
is
will
at page
get that.
48. Kindly come to me.
So in that case, let them consider your representation, the PHE, until your representation is disposed of, no further
Status quo? Yes, my lord, no further.
no further step will be taken on the
Yes, ma'am.
land.
It will be better if you district magistrate consider my
No, no,
representation.
PHE,
Because land department handed over the property to the PHE. So they will straightway say, I got the property from the Department of
Yes,
Land.
PHE cannot deal with it.
Then
They
district
have
magistrate.
just received the land.
Then district magistrate.
They will not own any responsibility.
Lordship.
PHE. Let the district magistrate consider.
District magistrate.
Affidavit of service. It is submitted on behalf of the petitioners. That the original owner of the plots in question, Indubala Kaur, since deceased, acquired the same by virtue of a deed of gift executed in her favor on 31st July 1947, as well as by virtue of purchase in the same year. Stop. The said plots were declared as vested under section 14, capital T within bracket 3.
প্রথমে ভেস্টেড হয়েছিল না, তারপর ডাইভেস্টেড করলো, এটা পরে করে হাইকোর্টের অর্ডারের উপরে।
In connection with 7 West Bengal Land Reforms Act, in connection with 7AA, capital A, proceeding. And
তামিল করেনি বলেই ভুল হয়েছে
such vesting was
তামিল করে
subsequently
তামিল করে দিলে আর কিছু
set aside, and the plots in question were allowed to be retained by the Rayat. Stop. The petitioners are the legal heirs.
legal heirs.
The petitioners, being the legal heirs of the original owner, have inherited the property after her demise. After her demise.
Of Indu Balakar. They are the sons of Indu Balakar.
The petitioners complain that the Public Health Engineering Department has affixed a board in the plots stating that the land belongs to the said department and shall be utilized for the purpose of surface water supply scheme. Possession of the land has been taken over by the said department the petitioners said department, though the plots have not been acquired in accordance with law. The petitioners submitted a representation before the concerned authority on 31st May 2022, ventilating their grievance, which is yet to be considered. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the fifth respondent be directed to consider the representation in accordance with law.
My lord, in the light of the, as because my lord, otherwise they will not, that is order dated 29th July 1994, my lord.
Page 33.
Yes, my lord, page 33. That is case number.
Yes.
That should be considered. Otherwise, my lord,
In
Case number 31 of 1990.
In view of the above,
BR case number
action is disposed of,
16A, my lord,
directing the fifth respondent to
22C by
consider and dispose of the representation submitted by the petitioners dated such and such
Kunta.
within 1 month.
Yes, my lord.
Within 1 month from the date of communication of this order, upon affording order in the light of the observation
Yes,
made
ma'am.
in the order
That is
passed on 29th July 1994
in CR number, my lord.
BR case number 31 of 1990.
BR case number. BR case number 31 of 90, my lord. BR case, page 19, my lord.
Page 19.
Review of BR case number 31, right?
in BR case number 31 of 90
Yes, my lord.
passed by the
Block Land and Land Reforms Officer, Nondigram.
Block Land and Land Reforms Officer,
Nondigram 3.
Nondigram 3.
Yes, my lord.
Nondigram, Roman 3.
Roman 3.
And upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, pending disposal of the representation, no further step shall be taken by the respondents in respect of the plot in question.
I'm good.
Disposed of which outline? Plots in question.
Number 33.
Lordship, item 33, I appear for the petitioner. I am led by Mr. Rudraman Bhattacharya. May I pray for a note this week, Lordship? If it could be taken up any day
Respondents,
next
your
week,
appeal.
Lordship.
I appear for the respondent, my lord. My lord, maybe please to take it up Wednesday or Thursday. My lord,
Ensure that-
because of this difficulty.
I'll fix up next month. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 11 July.
As your lordship pleases.
Great.
Keep rolling.
Number 34.
My lord, and earlier and direction was issued, my lord, for further service upon one respondent, number 8, possible. This is the
Respondent number 8.
private respondent.
Have it served?
Sir, further, sir.
Yes.
My
Anyone
lord,
appearing for the private respondents? No one. You are appearing for the state? Yes.
my lord, this is a case, my lord, construction over a PWD road, my lord, Bash Road, my lord, in front of the petitioner premises. My lord, thereby the access of passage and the ingress and egress, everything has been stopped, my lord. He has also made fence, totally fence there, my lord. The page 16, I photograph also there, the fence, totally fence. And
Have you made a representation?
yes, page 17, page 17. Well, in accordance with law under the provisions of section 8 and 10 of the my lord, the Highway Act, my lord, the authority.
Let this be considered.
Yes, my lord.
Mr. Paul?
Respondent number 4, my assistant engineer, highly action given by assistants.
3 and 4.
Yes. So
No,
let
no,
this be
not clear.
considered.
Only
4 assistant engineer.
no, 4.
Affidavit of service. None appears for the private respondents despite service. Paragraph. The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his plot, thereby obstructing his ingress and egress. The petitioner submitted a representation in this regard before the concerned authority on no date. Representation?
Date. This is my page 19, my lord.
On 1st April 2022.
1st April 2020.
Which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents that the 4th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the 4th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this
Under the
order.
provisions of the Highway Act, my lord.
Under the provision of the Highway Act.
Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
In this matter, but I appear with Mr. Susunu.
Next.
Okay, regular.
May I please your lordship? I am for the petitioner. My lord, this is a case about removal of illegal construction in front of my premises. That is a self-acquired property. I'm the owner by dint of
sale deed. The front portion is the PWD land. It is the opening, my lord.
It's your affidavit of service.
My lord, my
Have
affidavit
you
of service.
served the private?
I have all of them. I have served all of them. It has been duly delivered as well. None appears, but my lord, I have served all of them. I think please see. Yes, your lordship. Lord, I will also give you affidavit service.
Yes.
My lord, may I please your lordship to draw your lordship's kind attention to page number 53. My lord, the report forwarded by the concerned police station to the subdivisional officer supports my claim, my lord.
53?
Yes, your lordship, page 53.
Yes.
The private respondents, being the encroachers, are present. They have set up, they have obtained trade license and everything. They have completely stopped my front portion. They are being the biggest obstacle, my lord, as for which I'm suffering. My lord, this report will support my case, I suppose.
It is on government land, PWD land.
Yes, your lordship.
Mr. Mundo,
On the basis of the kindly see the page number 57.
take the microphone, please.
Page number 57. The assistant engineer already issued the notice to the concerned officer BLRO for demarcations of the portion of the land. And already copy already.
Then
sent
what
to
has happened after that? After that,
Lord,
this is sometime in August 2022.
Lord say,
Has the demarcation been done?
on the basis of the land of the 4 kilometer of the Amta road.
Demarcation has been done?
Lord say,
Where is the report of demarcation?
that according to the petitioner grievance, my lord, the within 4 kilometer petitioner portions of the land not found.
Where is the report?
The report may be submitted.
Copy of the same has also been forwarded to me, my lord. I'm item number 5. I'm the addressee number 5, my lord. But it is only in black and white. As per my instruction, it has not yet been initiated, my lord. And I'm suffering the same thing, same problem as it was for the last few years.
Petitioner and private respondent also involved.
This is a request for demarcation.
Lord say,
You say that the demarcation has been done.
BLRO is the competent authority for demarcation.
Have you done the demarcation? Has the BLLRO done the
It
demarcation?
is report necessary my lord, at this stage.
Let him come back with the report.
Okay,
Because
as
the
your lordship,
case is
please.
done, then the report also
Lordship.
supports you.
My
So
lord,
necessary order can be passed.
yes, your lordship. Then some order may be passed in that regard, maybe. Then I can able to.
The petitioner service. Service current upon none appears for the respondent numbers 6, 7, 8, 9, 10, 11, 12. Despite service. Paragraph, the petitioner alleges unauthorized construction made by the private respondents on PWD land adjoining his property. Stop. An inquiry report submitted by the Sub-Inspector Amta Police Station before the Subdivisional Officer, Uluberia, Howrah supports the claim of the petitioner. Stop. Record reveals that the Block Land and Land Reforms Officer Amta-Roman 1, Howrah was requested to demarcate the government land on which the alleged encroachment has been made, by a letter issued by the Assistant Engineer, Amta Highway Subdivision, PW within bracket roads, Directorate on 29th August 2022. Stop. Paragraph learned counsel for the state respondents fails to apprise the court as to whether such demarcation has been made till date. Learned counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 4th July.
4th July, not
Much with this, Your Worship.
4th July as well.
Although the APT was service be kept on record.
Yes.
Much with this, Your Worship.
Next.
And number 36.
Let I appear for the petitioner.
ঠিক আছে, অসুবিধা নেই, ওটার সাথে দিয়ে পাঠিয়ে দিন।
Lord, I appear for the petitioner. Let the affidavit of service.
The state. AMD and the state also.
State is also a part.
Urban Land Department, yes. Served. State has been served. So may I request Mr. Dave,
This is second round of litigation.
please serve a copy to Mr. Day. I'll request him to appear in this matter. Now that's why I'm requesting Mr. Day to appear. Please serve a copy to him. Yes, what is the matter about? Please switch on the microphone.
Lord, the petitioner had applied for a HIG plot of land. By way of lottery, my lord, the application was, first of all, my lord, the application was made, it was scrutinized and being found okay, my lord, lottery was held. In the lottery, my lord, she was successful. Now she was issued a letter of allotment. That was in general letter of allotment of a plot. And there were certain terms and conditions. One-time payment of the entire amount or installment payment and other formalities to be complied with. Now, my lord, thereafter, a specific plot of land was also allotted by the government. Now, my lord, as per the terms and conditions, my lord, the petitioner paid 1,65,000 the one-time payment for the plot of land and submitted the receipt. On the basis of the same, my lord, deed was entered into, executed, deed of license in 1999. But the possession letter was not issued. Several representations were made. There were internal communication. I'll draw your lordship's attention to that because they say
I am entitled to the plot of land. The land is free of encumbrances. It is lying vacant. And even the deputy secretary was informed that the plot can be handed over to the applicant. In spite of that, nothing happened, my lord. I came before this court. Your lordship passed an order, my lord, that is at page 58. My lord has got it.
Yes.
The grievance of the petitioner is that despite being allotted a plot of land by the Kolkata Metropolitan Development Authority and execution of indenture on 15th September 99, upon clearance of the entire consideration demanded by the authority, the possession of the plot has not been handed over to the petitioner till date. It is submitted on behalf of the KMDA that it is the usual practice of the authority that the indenture is executed only after possession of the land is handed over to the lessee. It is a fact that the authority is unable to produce any possession certificate issued in favor of the petitioner in support of his contention. Be that as is may, the petitioner prays for a direction. Now, my lord, in terms of the direction passed by your lordship, my lord, a hearing was given. Now, my lord, the total perverse finding, my lord, they have tried to increase with the flux of time. They have put certain new conditions, denying that I am not entitled to. Now, my lord, that is at page 61, the impugned order. During the course of hearing, second paragraph. During the course of hearing, Srimati Monica Ghosh has stated that she had applied for a plot in 2017. That is totally, my lord, contrary to records. It was applied in 1994, my lord. In 1995, my lord, 94, my lord, I paid the entire consideration money. In 1999, the agreement was executed, deed of license. And they say, in 2017, I have applied. Now, my lord, and paid the provisional premium thereafter. She has further stated that she comes from a low-income family. My lord, how did they come to this effect? I don't know. Because in 1994, my lord, I have paid a one-time amount of 1,65,000 as per their demand. And now they say, and her husband is a jute mill laborer. And they reside at Andul at present. She claims that earlier she resided at Chandannagar. I have changed, my address has changed with the flux of time, my lord. From the available record, it has been ascertained that a formal allotment letter was issued in 94 for a high income group plot bearing GA 137 under category HIGP, wherein the monthly income slab was fixed at rupees 2,500. Now this is not, it cannot be a consideration, my lord, after 30 years. After taking the money, enjoying the money for 30 years, after allotting me the plot, only the possession letter has not been issued, and now these reasons and grounds has been put forward. Incumbent has failed to produce a specific allotment letter, my lord. Kindly see the demand made by them, my lord, at page 48. They demanded voter identity card, allotment letter, license deed, deposit receipt, page 48. My lord has got it?
Yes.
At page 49, my lord, I have deposited all the documents. Huh? And my lord, kindly see the letter of allotment, kindly come to page 19, my lord. This is the specific allotment of
Page 99.
19. I am directed to inform you that in a lottery held on such and such at Regional Computer Center, Calcutta, Jadavpur University, plot number GA 137 has been allotted to you. And page 20, my lord. Kindly come to page 20, my lord. That is the initial lottery was held and allotment was made. This page 19 is a specific plot which has been allotted to me. But page 20 is the general allotment. Now, my lord, kindly come to the terms and conditions. Page 21, my lord, clause 7A, outright payment scheme, and 7B is installment. I opted for 7A and I have paid the entire amount at one go. Now, my lord, kindly come to page 24. clause 9 and 10. These are very important, my lord. My lord has got it?
Yes.
An allottee will have to execute a lease deed with CMDA in the prescribed form after payment has been made by him in or her in accordance with paragraph 7A. That has been done. My lord, that is, your lordship will get at page 26. The receipt. Now, my lord, possession of the plot will be handed over after receipt of full amount of premium with interest, if any, under the outright payment scheme or of 3 installment. I am not on that, my lord. I am skipping 3 paragraphs, together with incidental charges and quarterly installments if fallen due in the meantime. And kindly mark this, and on execution and registration of the lease deed. My lord, lease deed are executed. My lord, kindly come to page 27. My lord has got it.
Yes.
This was executed on 15th of September 1999. My lord has got it at the. So after the execution of the lease deed, the possession certificate has to be issued. Now, my lord, what is the internal communications? Kindly come to. They have verified that the plot is vacant, my lord. That is at page 45 and 46. 44, 45, 6. They internally inquired and said that plot is lying vacant. Now, my lord, kindly see. I have shown, my lord, page 48. These are the documents which they wanted me to submit without which I have submitted. Now, my lord, page 51. My lord has got it. Page 51. In response to your letter number as stated above, the plot that is GA 137 category HIG under EKAD project has been verified and it is found that the plot is lying vacant. My lord. Next. Again, they wanted me. Page 52, my lord. Kindly come to page 52. Thereafter, again, they wanted me to submit further documents. Same documents, which I have submitted earlier. Kindly see allotment letter, license deed, money receipt. I have submitted, my lord, page 53. Now, kindly come to page 54, my lord. This is very important. My lord has got it?
Yes.
I am directed to inform you that I am enclosing here with the photocopies of allotment letter, money receipt, license deed and right and title report, along with site plan in respect of plot number 137 in HIG category at block GA under East Kolkata Area Development Project, which was allotted to Srimati Monica Ghosh by KM. That is the petitioner, my lord. Next, in this regard, you are requested to let us know the present status, whether encroachment or dispute of plot number such and such, along with color photographs, and whether you are ready to hand over physical possession of the above mentioned plot to the above named allottee. This is, my lord, in 2020. Now, my lord, in response, my lord, page 55.
So, Mr. Dey, you need to take some time for making a submission on this?
The state has
Not
nothing to
necessary,
do, my
state
lord.
has
It is the KMDA.
Wait.
Now, my lord, kindly come to page 55, my lord.
Yes.
The executive engineer is responding to the letter of the deputy secretary and saying that in response to your letter, project the site inspection of the said plot, it is found vacant at the time of inspection. So still now it is vacant now. Kindly come to page 56, my lord. My lord, the second paragraph I am reading. In this regard, I am directed to request you to let us know whether you have any record related to allotment of the said plot in favor of Srimati Monica Ghosh. If yes, furnish the same for our record. This is this section officer responding to the chief engineer. Now, you are further requested to inform us that whether you are ready to hand over physical possession of the above mentioned plot to Srimati Monica Ghosh. My lord has got it. Next, page 57, my lord. In response to your letter dated such and such, the the plot is lying vacant at present, but there is no office record lying in our office about the allotment of land to Srimati Monica Ghosh. Now they are not these documents, they wanted me to submit those documents, we submitted that. And what they say is the plot is presently in vacant, so the physical possession may be given to the allottee. Thereafter, my lord, nothing happened, so I came before your lordship. Now, my lord, kindly see the impugned order, my lord, which I was reading, my lord, page 61.
Yes.
The third paragraph. The incumbent has failed to produce a specific allotment letter, contrary to record, my lord, which is as usual practice to issue in favor of incumbent immediate the issuance of formal allotment letter. It reveals from the documents provided by the incumbent that license deed was executed on 15th September. My lord, unless the allotment is made, my lord, how can a lease can be executed? An incumbent paid the provisional premium of 1,60,000 on the outright scheme on 94. The said deed, it was mentioned that in consideration of the purpose for which the plot of land hereinafter referred to and the mention in the schedule as hereunder written is required by the licensee, and in consideration of the annual rent and licensee's covenants, hereinafter reserve the authority doth hereby grant to the license leave and license to enter upon the land more particularly mentioned and described, such and such. This reflects that possession was handed over to the allottee the day of execution of the license deed, if not earlier. You know, the terms and conditions says that after the execution of the deed, my lord, they will issue me the possession letter. So it is on presumption. But they have not been able to produce a single document showing that the plot of land was handed over, physical possession was handed over to the allottee. Now, my lord. My lord, had the physical possession been handed over, my lord, I wouldn't have waited for so many years and approached this honorable court. Now, as per clause 2, such and such, my lord, I am not going on that. The second paragraph, my lord, last 4 lines. The resolution of 183rd authority of meeting of KMDA states that in case of non-construction, my lord, how can I construct unless I am handed over the possession letter? Now, next paragraph. As per status of the plot received from the engineering section, the said plot is found lying vacant. A plot was allotted to Srimati Monica Ghosh having address mentioned at the formal allotment letter as Jahanabad, Hazinagar, Chandanagar, Hooghly, but the incumbent could not produce any such document in support of a residential proof of that type. Well, I have already informed them all communications were made from the present address. In 94, Millard, I may have lived at Chandan Nagar. The incumbent informed to communicate her at new address. Now, it further appears that there are mismatch in signatures. Well, that can be a ground after 30 years. And on this ground, Millard, HIG plot and incumbent by her own statement does not belong to HI group. Now,
After the deed has been executed, only the possession letter was removed.
Whether that allottee Monica Ghosh is the present, the petitioner Monica Ghosh, that's the question. That's the question. No. Which is in the impugned,
Come back
in
on
the order
evidence,
impugned.
let the order be stayed for the time being.
No, in the order impugned, Lordship will find there is a mismatch of signature. And firstly, and secondly, my lord, this HAG category plot of land is allotted to a group of income family.
That ought to have been decided earlier.
And admittedly, during the hearing, she deposed. She came from a low income group family.
There is no admission.
So
This is your contention.
yes.
No, this was
Please come
submitted,
back on
that has been
affidavits, Mr.
recorded.
Parikar.
So this
There
is
are certain
what was
disputes of fact
submitted
which
during.
need to be dealt with.
No, that has not been denied in the writ petition in amendment. So no, there no ground, no specific ground has been taken in the writ petition, denying all these points taken in the reason order. No specific ground has been,
Signature
no
does not
specific,
apparently match.
there is mismatch of signature.
There is apparent mismatch, not mismatch of signature.
Yes.
There is a lot of difference between apparently and
That has
a
to be
mismatch.
examined. That has to be, that can be sent to an expert to examine that. And another aspect, my learned friend has not placed that in 1994 allotment was made. During the 1995, she made payment. The LOT Monica Ghosh, I am not admitting that this petitioner is that LOT. I cannot. And it is an admitted fact, my lord, even after execution of license, instead of lease, license was executed and she accepted. The LOT Monica Ghosh had accepted. License deed was executed. There certain conditions have been put for making construction within a certain period. On failure, the penal measure was also there. This was executed in 1999. But what she was doing, had she not received possession of the plot, why she was silent over for more
She
than.
was not silent at all.
Yes, she was silent.
There are several communications.
Several commission when started? Lordship, from 99 to
Mr. Talukar, I
2007.
think please come back on affidavits.
From 1999 to 2007 is the first representation, first letter. So what she was doing for all this year, when there was a specific covenant to make construction within 5 years, she knew, the LOT Monica Ghosh knew.
Please place
that
your
if she
facts
fails
by
to
way of
make
an affidavit.
construction within 5 years, the allotment will be cancelled. But she kept mum. For the first time in 2007, admittedly from the writ petition.
It has not been cancelled, my lord.
No, that's a different thing.
That is not a different thing. You are standing before a court of law making submission which is contrary to record.
Not contrary to record.
Obviously, your record says it is lying vacant.
Show the honorable court a single document that after 99, before this page 32.
You are the custodian of the documents.
Page 32.
You are the custodian
August
of the documents.
2007 is the first letter. What she was doing, Milord, since 1999 to 2007.
Unjust
when there
enrichment
was
by the government.
Even you cannot deny that Monica Ghosh was
Denying a citizen of her right.
license was executed in favor of the licensee, Monica Ghosh. There was a specific clause, covenant, to make construction within 5 years.
Without having the possession letter, I can construct. And the day after tomorrow, I will be sent to jail.
Why
Constructing on the plot of land of the government.
I have not interrupted you when you were making submission.
There is
Please
in
allow
fact
me.
no document between 1995 and
2007.
I have stated that the reasons why I could not make any at that point of time. But they have accepted my representation. They have made inquiries thereafter. They have come to the conclusion that I am entitled to and I can be handed over the possession. Now the past period goes.
Even in the subsequent.
They cannot change their stand, Milord, with the influx of time.
2007 onwards, letters does not.
Okay, Milord, I am not on 2007 onwards.
You
I'm
initially said that it should be heard on affidavits. Come back on affidavits.
Let us file a petition. There are many things, my
The
lord.
order will be stayed in the meantime.
Yes.
Otherwise, the petition becomes infructuous.
And Milord, no third party interest should be created as
order-
my lord.
The order passed by the Secretary KMDA on 12th July 2022 is assailed in the writ petition. Paragraph, upon considering the submission made on behalf of the parties, this court is of the view that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks.
All
4 weeks.
This is the second round of litigation, Milord. They are in possession of all the documents now.
Within 4 weeks from date, stop affidavit and reply, comma, if any comma be filed within a week thereafter. Within a week thereafter. Paragraph, let the matter go out of list for the time being. Stop, liberty to mention. Paragraph, since the
Give us 4 weeks.
order dated 12th July 2022 is under challenge, comma. Operation of the said order be stayed Until further orders, stop. The respondents shall not create any third-party interest in respect of the plot in question till the matter is decided by this court.
Let it be for a limited period.
No, no, no.
Otherwise, the writ petition will not be listed and heard. Let it be for a
File
limited.
your opposition, it will be listed.
Give us 4 weeks time.
4 weeks have given, 4 weeks. 4 weeks and 1 week.
Unless your lordship mentions that limited period, the matter will not be heard.
Kindly make it, fix it after 6 weeks.
No, no, please come back. Please mention after it is, he is in a hurry.
Let there be a direction, Milord. It will not come automatically, Milord. We have to mention, Milord, but let there be a direction. Otherwise, Milord.
To mention.
Liberty
So
to
please
mention.
mention after you.
Liberty to mention.
There are many things to be gone into, not those.
Enjoying 1,65,000 from 1965.
Please come. Next.
Liberty to mention.
37.
Lord, item 37, my lord, I am for the petitioner.
State, my lord.
Lord, copy has been served upon all the respondents, my lord.
Your affidavit of service?
Yes, my lord, affidavit of service is ready. Lord, Lord, sorry, my lord, because my lord, the service copy upon the my lord, learned government pleader, my lord, in the 0 page, it is mentioned group 9 wrongly, my lord. So, my lord, let it.
But the act is there. 64 act.
And my lord, I am not wrong, my lord, your lordship's copy is correct, my lord. My lord.
No problem.
Yes, please make your.
My lord, this is, my lord, my land adjacent to the PWD road. My lord, the private respondent, my lord, they started construction and my lord, to set up shop, as a result of which, my lord, we are not in a position to enter into our land. My lord, we filed 3 writ petitions against 3 respondents. Now, my lord, the 3 writ petitions disposed of, and accordingly, my lord, in a contempt proceeding, my lord, the PWD assistant engineer, PWD roads, my lord, started proceeding under section 10. And challenging that order, my lord, the private respondent number 10 moved a writ petition before this honorable court. My lord, Justice Mousumi Bhattacharya, my lord, was pleased to direct the SDO Bosirat to complete the proceeding under section 10(2). Accordingly, my lord, the assistant engineer PW Bosirat, my lord, wrote a letter to the my lord, SDO to complete the proceeding. That has not yet been completed. Lordship, kindly turn to page 44 first. Page 44.
Yes.
My lord, thereafter, my lord, the order of my lord Justice Mousumi Bhattacharya. Page 45. And in terms of the order, page 47, my lord, the respondent number 4, assistant engineer PW Roads, my lord, made an application to the SDO Bosirat. So my only prayer before your lordship, kindly direct the respondents, my lord, to complete the section 10 within a time bound period.
Respondents করতে হবে না, respondent করতে হবে, SDO করতে হবে। SDO কে ডাকতে হবে, এখন SDO গেছে না, তাই বলবি। পাঠিয়ে নেই বলে।
Yes, so let the proceeding be concluded
Completed hai.
within 1 month.
One month. Respondent number 2A, my lord.
SDO.
There is
Yes, yes.
SDO.
Affidavit of service, none appears for the private respondents despite service. Paragraph. The petitioners. Huh? Yeah, thank you. Regularize করবে। The petitioners allege unauthorized construction made by the private respondents on PWD road adjoining their property. Stop. It appears that upon demarcation of the plot allegedly encroached upon by the private respondents and detection of encroachment therein, comma, proceeding under section 10 of the West Bengal Highways Act 1974 has been initiated. Stop. A coordinate bench of this court, comma, by an order passed on 11th August 2022 in WPA 16237 of 2022, directed the state authorities to hear the matter afresh and complete the entire exercise within 6 weeks from the date of order. Stop. Pursuant to the said order, comma, application was made by the assistant engineer, comma, Boshirhat Highway Subdivision, comma, PW within bracket roads directorate to the subdivisional officer, comma, Boshirhat, North 24 Parganas on, what is the date of the application?
Next page, my lord, last page.
18th August 2022. Under section 10(2) of the Act of 1964. Stop. Paragraph, it is submitted on behalf of the petitioners that the proceeding is still pending. Paragraph. Learned Counsel for the state respondents submits that respondent number 2, small a, be directed to conclude the proceedings in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since proceeding under section 10 of the Act of 1964 has been initiated, comma, the concerned authority being respondent number 2, small a, is directed to take the proceeding to its logical conclusion within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
Communicate the
Yes, sir.
order to the petitioner, the reasoned order.
Not necessary, because it's a proceeding, you will be heard.
Oh, sorry.
Disposed of. Next.
No, 38.
My lord, my lord, I appear for the petition.
My lord,
Your lordship have direct.
in this matter, my lord, last occasion I took time, if your lordships, praying internally, my lord, that I have to send the, my lord, I have to communicate to the concerned authority for release of the fund. But I have talked to my officer, my lord, that because the land has been utilized by the PWD department, we have acquired the land. We have also passed the order that they are entitled to get the compensation. My lord, I have got the information from the authority, my lord, from the, my lord, special land acquisition officer. They have already wrote a letter to them and for release of the said fund. As yet, my lord, they have not received any information
How
from
long
them.
you want?
So I pray for certain hour more time, my lord, because they have already wrote.
Let them file a report, my lord.
Report. I'll file the report. That's why. I will file the report.
Self-same scheme, my lord. My lord, they have said that there is no acquisition. They will pay compensation.
No, in this case, my lord, in this case, we have
According to
specifically
market
stated that they are entitled to get the compensation. That's why, my lord, my officer
Another
has instructed.
Okay, here, it is recorded in the order that they have acquired the land.
Yes.
And they are waiting for funds.
Yes.
But
Another 2 weeks?
Another 2 weeks, my lord.
Funds
Just,
will be
yes,
available.
another 2 weeks.
they don't pay another within 2 weeks, at least they come up with a report, my lord.
I will come up with the report. Last occasion, I said so, my lord. I will come up with the report within the form of an affidavit.
Let the report be filed, my lord. Everything will be clear.
Learned counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as called for. And further submits that some more time is required for receiving fund
Yes.
from the Public Works Department
Lovely.
for payment of compensation to the petitioner.
Yes.
Paragraph, let the matter appear under the same heading. Not only report, please ensure that the compensation
Yes,
is
yes,
paid
yes.
to the
Yes.
petitioner. by
Along with the
next
report,
day.
my lord, I have said so. My lord, I have said so. So that money can be paid.
6th July,
Yes, my lord.
sufficient time.
Yes,
please comply with
6
the order.
July, my lord.
Number 39.
Last occasion also have submitted the agreement of service. Now, upon mentioning, also have served notice to the learned advocate for the state. This is the notice.
Mr. Mondal, your
Lordship. Now, Lordship, this matter, the dispute relating to the issuance of, Lordship, the land loser certificate. Now, Lordship, initially I moved the writ petition. Now, Lordship, they have passed a reason order. Now, that is page 97. Now, Lordship, in the instant case, the Honorable Justice such and such had been pleased to pass an order dated 9th December 2021, wherein the Director of Employment West Bengal, Restaurant 4, has been directed to examine carefully all records, if necessary, require further records of the writ petition and pass a suitable order, such and such. The instant writ petition has been filed basically for registration of the name of Suparna Biswas, alias Somaddar, at EC sale and land loser, who happens to be a granddaughter-in-law of the original land loser, let Sitish Chandra Biswas. The petitioner and his father-in-law was requested to submit further records regarding the instant matter. but they did not submit any additional documents. The entire facts of this case is, Lordship, they encapsulated herein in a chronological manner. Original land belongs to late Sitish Chandra Biswas, such and such, land measuring 20 decimal. Effectually 30 decimal was the agricultural land situated in Mouja, Chaya, Goria, and board such and such. The government acquired land for public interest, land acquisition collector, 24th Paraganas, notice dated such and such, such and such. Now, the petitioner SUVRA Biswas is a granddaughter-in-law of the original land loser of Satish Chandra Biswas. As per the Labor Department notification number, only one member of the uprooted affected family shall be eligible for consideration against the vacancies reserved for the exempted category. Now, the beneficiary shall be either an awardee of compensation or the acquisition of land, or a member of the family of a awardee. The Labor Department memo number 03 dated 5th January 2005 decided the family definition is, Lordship, the land loser himself, wife, husband, or dependent sons unmarried. Now, in considering the notification of 2005, Lordship, I am not within the definition of family. Now, Lordship, I have challenged this order before your Lordship. Now, for Lordship placing the order of your Lordship at page 99, Lordship, I am just kindly allow me to place one order of the Honorable High Court, Lordship, that is page 106. Now, in the 106, the same and identical issue that prior to 2002, the land was acquired, land loser certificate was refused in terms of the notification of 2005. The Honorable High Court, in terms of this order, that is Subrata Hajra versus State of West Bengal, has decided that land was acquired prior to 2002.
In this case, when was the land acquired?
This is prior to 2002, 1993. Now, prior to 2002, as the land was acquired, so 2002 notification is applicable. So 2005, relying upon the 2005 notification, the rejection order is illegal. Now, this is the 106, page 106. Lordship, the kindly come page 107, this relevant part, last paragraph, this is simply erroneous. Rights were created by the notification dated 21st August 2002, and right to nominate a family member for employment was included as per the said notification. The notification was in exercise of the statutory powers. Now the vested rights could not be easily taken away by a subsequent notification. In fact, there is no recital in the subsequent notification that it would be retrospective effect. In fact, subsequent notification could not have been a retrospective effect to take away the vested right of the land loser and his family members. To that extent, the subsequent notification is bad in law. As per the writ petitioner has not asked for quashing of the same, I am not setting aside. The notification of 2012 is simply ignored as being non-est. The interim order passed by this court in this writ petition directed inclusion of the petitioner's name provisionally in the list of exempted category candidates. Under this circumstance, I direct the respondent number 4 to immediately register the name of the petitioner in the exempted category consisting the land losers permanently and not provisionally for a as directed by the interim order, and this should be completed within 4 weeks from the date of communication of this order. Now,
what is
this order
notification of 2012. This order refers to a notification of 2012. What is that notification?
To
page 108.
Yes, but no, this is 2000. This is now relying upon the 2002. The petitioner has been given benefit of 2002 notification.
The notification of 2012 is ignored. What is this 2012 notification?
So I will. So far, our rejection is 2005, but the
order says 2012. That's why I'm asking. The first paragraph, last line?
Yes, yes, yes. Lordship, this is maybe a reason order, perhaps. I don't know, this is maybe reason, but Lordship, from this order, I am relying upon that the court wants to give benefits that as the land was in Lordship, they acquired prior to 2002, so 2002 notification is applicable. Now, this order was under challenge before the Honorable Division Bench, that is page 109. Now, Division Bench has upheld the order of the Honorable Single Judge, and Lordship, the appeal has been dismissed. Now, this order of the Honorable Division Bench, now subsequently I got the information after filing the writ petition. It was SLP was preferred with the Honorable Supreme Court, and SLP is also dismissed. This is the order of the SLP. Now, Lordship, kindly come your Lordship's order at page 99.
Mr. Mukherjee, you'll take some more time. So
Lordship,
will you
it will
continue
take
some, will you continue some other day?
Lordship. Next week, any day, Lordship.
I heard learned counsel for the parties. Paragraph, paucity of time intervenes. Paragraph, let the matter appear under the same heading for further consideration. On 19th June.
19th June. So kindly, I'm praying for some preference in the Lordship.
Before Lordship rises, my Lord, original side item number 2, that election petition trial. I just need to inform your Lordship that the witness could not make himself available today. I just wanted to inform your Lordship so that Lordship can appear.
Please come back at 2 o'clock so that I
My
can
junior
fix
would
another
be there,
date.
Lordship may fix another date,
Yes,
any day convenient to the bench. my
And
Lord.
if learned,
I have informed the other side, my Lord, he is also here. We'll come back at 2
please
PM,
come back at 2
somebody will
PM.
be
I'll
there,
just
ma'am.
fix another date.
Very well.
May I mention one matter? Kindly permit me.
Not mentioning time, sir. I'm sorry.
I know it is odd hours, my lord, but there's a bank guarantee invocation which may take place tomorrow. But kindly permit me to, my lord, affirm this and file it, my lord, and may it appear tomorrow.
File and come back.
Kindly
I
take
have
it up tomorrow.
rejected several prayers of the same kind today.
With the
File and come back.
problem is, my lord, my bank guarantee would be invoked. Otherwise, my lord, this is an allocation of coal block, my lord. They are saying that there has been some departure on my part. Forest clearance and environment clearance I could not get. It is not that I did not apply. It is the forest authorities and the environment authorities who could not give me the clearance, for which the screening committee has, my lord, directed penalty against me, and the recovery is made by encashment of the bank guarantee that we have already submitted before it, 42 crores. Kindly take it up tomorrow anytime, my lord. I'll serve notice and come back.
Leave granted.
I'm grateful.
What can I say?
Side, we have the petitioner's witness is not being able to come today. We had asked for a
Right,
date.
who's appearing for the respondents? You're appearing? When will you come back? July? On 6th July. করে দিই। থাক, 6 time যাবে।
New application, item number 1.
Item number 1, my lord, I beg to appear for the applicants, my lord. 116 number of applicants, my lord.
Shall I take up can 5 first?
Lordship, Lordship. This is my application, your lordship. I have
can 5 to হয়ে যাক
Can 5?
Can 5, your lordship. I have served the copy upon all
For
the
asking for
respondents.
addition of party.
Lordship, addition of party and for appropriate order, my lord.
What is the appropriate order that you're seeking?
Appropriate order, my lord, to the effect that, my lord, they can join their respective post, my lord. My lord,
Is there any bar? Why do you want an order?
lordship, the bar, since there is an order of stay of the transfer order, your lordship. As such, your lordship, they went to their employer, your lordship, and they have stated with the employer. They have been, your lordship, asked to your lordship for
Page
appropriate
25,
order.
paragraph 6, they have stated.
Paragraph
Page
6.
25, paragraph 6.
Paragraph 6,
It's a
your lordship.
Petitioner.
But he is for the
My lord,
petitioner, I am. তোমাদের 6 তো হচ্ছে না 5 হচ্ছে দাঁড়াও
No, 5. Who is the petitioner in the original writ petition?
Original writ petition, they
Mr. Mojumdar, you're
I-
appearing for the petitioner.
for the petitioner, your lordship.
You have no objection if this prayer is allowed. Can 5?
One of my prayers, some of the clients whom I represented, of course, that was a union's petition. But they are also seeking now, many of them have joined. Some of them are willing to join without prejudice to the rights and contentions in the writ
But
petition.
in 6 Malad, paragraph 6, they are
Paragraph
saying
6,
otherwise.
my
Will you
lord,
kindly
my-
see paragraph 6,
My
page 25?
application, page 25, my lord.
They say that they will go to their choice post, we shall allow them, they will join.
Intelligent employer.
Malad,
Intelligent employer.
My lord,
116 employees, they are
116, my lord, and they are suffering a lot, my lord. They have availed, some of the employees, your lordship, they have availed, your lordship, loan, your lordship. Now,
Mr.
the-
Mojumdar, you have no objection?
No, it's for the individual.
Not necessary.
extremely.
Can 5 of 2023. The applicants seek to be added as party respondents to the writ petition and pray for permission to join their respective places of service. Paragraph, it is stated, it is submitted on behalf of the applicants that the employer / Food Corporation of India is ready to transfer the applicants to the depots of their respective choice.
They have already given their choice. Follow this one.
Such choice has been furnished with the employer
By affidavit, Malad, they have submitted.
by way of an affidavit, along with a declaration that they do not want to be part of any proceeding any further. Paragraph, upon consideration of the submission made on behalf of the parties, the application being can 5 of 2023 is allowed. The applicants be added as respondent numbers. It should be 8 onwards. isn't
8
it?
onwards.
8 to
124. 116 are the applicants, my lord.
8 to 124
120.
in the writ petition. Paragraph, the applicants are at liberty to join their respective places of service as decided upon by and between the applicants and their employer.
As mentioned in paragraph 6 also.
That
Oh,
is
yeah, as you
recorded,
know, as
that
you
is
know.
recorded. Can such and such is disposed of accordingly. There shall have been no reversal costs. Urgent certified website copy. What about the other can?
Can 6 not is
Urgent certified website copy be furnished to the town. Yes, the next.
is with a prayer to join the places of service without prejudice to the rights and contentions. Please have a look at page 9. The list of workers is at page 77. 77 to 79.
But my submission is this. Well, there are 459 laborers total in the colony depot. 284 have willfully joined already early. Well, 116 have their can number 5. The rest is 59. 45 is the strength they have mentioned in paragraph 10 of this application. 45 is the strength. Well, in the same matter, well, the separate orders. But I'm saying to the lordship, this application, when the matter is writ petition is
You
that
have reservation with the part without prejudice.
yes, my lord, you'll also call is concerned. Right. Whatever the writ petition, if the writ petition we shall lose, they can win.
Why should this reservation be expressed? Why should this reservation be?
Question is this, my lord, let
Can't be that the employer can win over every worker in that way.
kindly allow me to submit. My lord, writ petition is at the final stage. My lord, everything have completion, affidavits have been complete, argument have been completed.
There should be a
filed.
There should be a limit to unfairness of an authority. Not I leave it, not I have placed my prayer, this is all.
Pass an order, we shall follow.
What is the difference? What is the difficulty if it is?
The lordship can well appreciate the difficulty to non-suit us.
My lord, question is this, my lord, whatever your lordship's decision will follow, we shall follow. But
what is the difficulty
this
if
is
it is
my
done without
objection.
prejudice to
No,
the
but
rights
this is
and
my
contentions?
objection. Now your lordship, but in one matter, one class of employees eating another one prayer, one they are.
It is their choice, sir.
It's just choice. But
Their choice.
they have exercised their choice. That's what we have allowed.
Whoever wants to join willfully can. Now, if they want to join without prejudice, what's the difficulty?
Kindly, kindly pass an order, but not by consent.
The prejudice contentions all are
Not by consent, you also pass an order, but kindly record that well. But they have language they have used. Well, you also kindly pass that order. I don't have any. I am not giving any consent, but your lordship kindly consider this. In one matter, my lord, separate orders. That's
without prejudice to the rights and
as your lordship. Then your lordship.
Because the matter will be dealt with on merits. And rights are and contentions are already
there in the matter.
They are in the writ petition,
As
so there is no difficulty. Can 6. The petitioner is the union.
Pages 77 to 79. This is the list of 45 workers and members.
The petitioner, the applicant, the applicant herein represents how many workers?
45 workers.
45 workers of the respondent authorities and seek liberty to join their respective posts without prejudice to their rights and contentions as may be dealt with in the writ petitions. Paragraph. Such prayer is allowed paragraph, the workers being 45 in number, comma, are at liberty to join their respective places of posting without prejudice to their rights and conduct. Can such and such is disposed of? Urgent certified website copy.
But only one thing is by this learning depot, other repetitions are concerned. Your Lordship, kindly, I am praying, Your Lordship, and I can only pray. Your Lordship, kindly pass the main matters to be disposed of.
I know. Even I am a little embarrassed with this.
It is my prayer, my lord. Only thing is I can pray only.
That's why I had suggested release of the matters.
have your lordship,
but-
My lord, release.
Sir, what do you suggest? Can I release the matters?
Please don't. As and when your lordship will be requiring our assistance,
Being
we
very
shall
difficult.
And as and when your lordship, whatever is there is there.
As and when becomes uncertain. So
Uncertainty is the hallmark of life.
Your lordship, we have given our extensive notes on argument. Your lordship, give your lordship.
yes, I had actually requested a recapitulation.
As and when your lordship desires our
the matter
presence,
any day, we shall
be
give an
presenting
answer.
ourselves before your lordship, subject to the convenience of court. Whenever your lordship pleases.
Let us see. Let us see.
Extremely great.
It's almost becoming redundant with all the workers
My lord,
joining.
there are not only Kolani, there are 10 depots. There's so many workers are there. Our main prayer that we have transferred them, all of them. We wanted the contract workers, but the main question is unresolved now.
I understand, but then with change of determination, it's really difficult. Let me
Yes,
see.
it is up to your lordship. If your lordship thinks that, if your lordship, whatever your lordship can.
What?
I can only pray before your lordship.
I understand. I am also embarrassed with this, but then let me see.
As your lordship. If your lordship, fix any day after 15 days, 10 days,
Please
next
come.
month.
Today it's only for the applications, so please
As-
come back. Good afternoon, sir. Election petition adjourned.
Much obliged.
সেরকম তো করতে হবে। এটাও পিটিশনার, এটাও পিটিশনার।
দেখো কত নাম্বার দেওয়া আছে দেখো। আরেকটু একটু কম
এটা ক্যান 6 থেকে ছিল। এই যে ক্যান 6, ঠিক আছে। আচ্ছা বলছি মিঠুন ভাই, আমাকে ইলেকশন পিটিশনের একটা পেপার এর একটা পেপার দিলেই হবে, কারণ জুরিসডিকশন গুলো দেখতে হবে। ইলেকশন পিটিশনের কি জুরিসডিকশন গুলো? কনস্টিটিউশনাল রিট। ইলেকশন পিটিশনের কি ইলেকশন পিটিশন, ঠিক আছে। আচ্ছা আবার
দেখাবো।
এপিটা কি হয়েছে?
6-7 তাহলে কি এটা কি এখান থেকে করতে পারবে? আচ্ছা 6টা দেখি। And the other questions are Joseph? Yes, so শান্তনু ডিসপোজালটা কি দেখাবে এবার? ডিসপোজালে তো আমাদের অরিজিনাল সাইড থেকে তো ঢুকবে না। কেন ঢুকবে? লিস্টের আছে নাকি? প্রসেসটা গন্ডগোল হচ্ছে, প্রসেসটা পুরো গন্ডগোল হচ্ছে। না না, প্রসেসটাই গন্ডগোল হচ্ছে। কি বলতো, মানে প্রথম দিন থেকে গন্ডগোল চলছে, সাইমultaneously দুটো লিস্টই থাকা উচিত। আমাদের তো এখানে উইথ করে দিচ্ছি, এবার উইথ করে আসা কিন্তু লিস্টে নয়। ওটা তো কিভাবে এসছে দেখো না, শুধু লিখেছে। অ্যাপ্লিকেশন দিয়ে কি হবে? তো অ্যাপ্লিকেশন আছেই ওটা। জুরিসডিকশনটা তো অ্যাপ্লিকেশন তো ওটা। বুঝছো তো? এবার আমাদের ধরো ইয়েতে ঢুকবে না, এটা সার্ভারে ঢুকবে।
WPO's সাথে
আমাদের বারবারই বলছে আমাদের যেদিন ডিসপোজ হবে আজকে জানি প্রবলেম হবে। আমাকে বলছি থাক বলবেন।
আমাদের তো কিছু নেই।
আমাদের সিট থেকে হবে
পুরো ভেটুগাই অবস্থা। उसके पास इच्छे करके फ्यूचर में नंबर राजा के पास जाए राजा जो भी है
the application, তাই তো? Can 5 of 10.
মিঠুন কালকে আমাদের কিছু নেই তো?
তো আবার না মঙ্গলবারও কিছু নেই তো।
Dispose of, তাই তো?
अच्छा
মেন গেট তো 2400
$20,400
किভাবে दिया
ওখান থেকে ক্যান দিয়ে করতে পারবে? এই ম্যাটার মধ্যে কোনো স্পিক হচ্ছে যারা প্রবলেম
এরা পড়ে যাবে ক্যান দেখে
ইয়ে দিয়ে তো ক্যান পাবে না। হ্যাঁ
দেখে তো হয়ে যাবে
আন্ডারে
দাদা বুঝবেন না
Then his battery is dead.
এবার অ্যাপল সেল
Supreme Court successfully has kept CC.
অ্যাপল সেল
अब ज्यादा कोर्ट बोलेगा ए तो हमारे पास दे दिया और आगे ये आपका सही है ठीक समय में ठीक नहीं करेगा अभी जाके नहीं
19,410
ठीक समय में ये विषय
হ্যালো অরবিন্দ মা কোথায় হ্যালো আর সুজিত ওষুধ দিয়ে গেছে হ্যাঁ তুই একবার নাও
কিন্তু তো আলাদা করে থাকছে তো এই কারণে আরেকটা হ্যাঁ
হ্যাঁ সুজিত ওষুধ দিয়ে গেছে
में है जब करने का टाइम बोला था आपके पास जाके
হ্যাঁ
लेवल है
হ্যাঁ
না
না না
बट करने का टाइम आप बोला था
তো আমাদের
হয়ে গেছে তো এখনো হয়ে গেছে
আমি বলছি এখন
ঠিক আছে
আর এটার পর আছে আচ্ছা তাহলে দাও
इसमें कोई गैर
নিউ মোশনটা বের করে দিলে হয়তো আর 5 মিনিট
আরেকটা রুট ডব্লিউপি
রাখছি
ভুল ভালো এরকম
इसको चल दो
है नहीं तो
তাহলে এখন জেরক্স যাব না তাহলে এখন জেরক্স যাব না
আমাদের সাইডে ছিল নিল কেন
এরা ভুল এই নিয়ে এখন ঝামেলা
হ্যাঁ
ওরা তো ডিসপোজাল আজকে নিয়ে নেবে কালকে যখন করতে যাবে
হ্যাঁ।
আমরা পাঠিয়ে দিই আমাদের ম্যাডাম বলেছে বলার পরে বলেছে আর একেবারে
तो बचा है उसमें 5% जो मिलेगा उसको ना उसको हमको दी दिया वो भी कम मैंने दे दिया कुछ भी दिखा तभी तो बोल दिया क्या हुआ
এখানেও তো আসবেন তাই না ওটা আসবেন
अलग अलग बोल से लगा
আমরা পাঠিয়ে দিই। কোন পেজে করতে না, কিন্তু এই ক্যান্ডিডেট চাইছিল এটা তো জাস্ট ইয়ে করেছে বোথ সাইড কনসেন্টিং অ্যাডিশনাল পার্টি হয়েছে। পরবর্তীকালে 19,410-এর ওপর অর্ডারটা অ্যাপিলে গেলে তখন অসুবিধা। ক্যানের জন্য অসুবিধা।
তুই তো বলেছিলিস।
হ্যাঁ বলেছি, এবার অসুবিধা হলে বলছি।
আর 22 নম্বর আইটেম তো
এদের এন্ডোর্সমেন্ট হয় তো ভেতরে। হ্যাঁ
তুমি দেবে গেছে সে আবার তার খাতায় এন্ট্রি করে নিতে দিতে হবে, ওখানে খাতায় রেজিস্ট করে নিয়েছি।
হ্যাঁ
इसका पूरा प्रीडिंग अलग सेपरेट बस हर दिखने सब अलग अलग का না আমি এখনই বেরিয়ে করে দিই একটাই হয়েছে মামলা হয়। আরে বাবা হ্যাঁ রে বাবা হয়ে গেছে না অ্যাকচুয়ালি হয়নি গ্রুপে ডাটা হবে না গ্রুপে না না আছে আজকে পরে আপনার 3 নম্বর ছিল হয়নি আচ্ছা একটা ডিভিশন করে দাও না একটা কালকে পর্যন্ত ডিভিশন তোমাদের আছে তো অমিতা কাল পর্যন্ত আছে তো হ্যাঁ হ্যাঁ আমাদের কাল করেছিলাম দেখো তুমি রিকুয়েশন 39 নম্বর পড়ে গেছে 10 থেকে সমিত দা বুঝলে 39 নম্বর করে রিকুয়েশন গেছে कैसे बोलते अभी तक सुनने स्टार्ट होगा यार इसमें नंबर आ गए हमारे पास अलाउ करेंगे हां जगह अलाउ करेंगे उन्हें छोड़ के पड़े रियल नंबर पड़े रियल नंबर समुदाय का पर से उसका तो मतलब टाइप हमने देखो
ও দরকার করা যায় বুঝলি গ্যাস শেয়ারে যায় ওই যে নিয়ে গেল কথা কোনো বলেছে বলে ये बोल रही आप
এখানে লিখেছো না
এসেছিল যে
অর্ডার পাস হয়নি তো ছয় সাত তাহলে বড় চাইটা কেটেই তো বড় তো নিয়ে গেল ছয় সাত তাই তো
এটা আজকে কিছু হবে কালকে ওরা যখন ডিসপোজাল করবে এই ক্যানের ওপর দিয়ে প্রবলেমটা হোক মিটে যাবে কারণ ওগুলো যখন মেন গুলোতে অসুবিধা
বেঁচে রাখো বুঝলে দাদা তো টাইপ হয়ে আসতেন না আমি কি করবো টাইপ করবো নাকি
বলছি যে ওটা পেন দিয়ে না ওই টাইপটাকে কেটে দিস তো
বেরিয়ে যাবে
তিনটে লেখা আছে কেটে দে মানে কোনো টাইমই থাকবে না
যা আছে
কেটে দিস হ্যাঁ ওটা ভুলে গেছি
আসলেই আমি দিচ্ছি
টাইম মানে
হ্যাঁ 3 PM টা কেটে দে আর ও মুখে কোনো টাইম নেই
ঠিক আছে
টাইম নেই কোনো ওই ডেট থাকবে টাইমটা কিন্তু
হ্যাঁ ওই দিয়ে বুঝতে হবে যে না আমরা রাখছি না এখানে ফোন করে বুঝতে পারছো বিয়েটা
কি বলতো
আমরা তো টাইপ করে দিয়ে দিয়েছি
অর্ডার পাস
আমাদের
তাহলে ওদের লিস্টে রাখবে ছেড়ে পাঠাবে কিন্তু সিস্টেমে তাহলে ডিসপোজ হবে
তাই তো
অনেকদিন পরে গিয়ে মেন অ্যাপ্লিকেশন পেন্ডিং এ থাকে
ওটাই ফোনে
সিস্টেমটাই পুরো গন্ডগোল করে দিয়েছো তোমরা কোনো সিস্টেমে তো নেবে না এটা
হ্যাঁ
আমাদের সাইডে কিন্তু আমরা সাইডে ওটা
এই এটা হচ্ছে একদম ইন্ট্রোডাকশন শুরু তারপরে তো তারপরে
তারপরে কি করবে সিস্টেমে নিচ্ছে
ভুল তো আমাদের এখান থেকে যাচ্ছে
আমরা যাচ্ছে না তোমার মাথাটা কাজ করছে না তোমার যেই লিমিট তোমার লিমিটে
একটা সাইড যখন হবে
যেটা করছো
আমাদের তো পড়ে
সেটা তো পাঠাবো ওদের
ওরা নিয়ে
হবে না তো
এখানে
ওরা নিয়ে
হ্যাঁ একটা করে ঠিক আছে হ্যাঁ হ্যাঁ কোনো ব্যাপার আর ওই চিঠিটা পেয়ে গেছো তো পাঠিয়ে দিই
তো সবই পাচ্ছে তো
সকালে যেটা বললাম না ব্যাংকে হ্যাঁ হ্যাঁ হ্যালো হ্যাঁ বুঝবো আপনার খুব আসবে বলেছিল আসেন তো যে কপিটা নেওয়ার জন্য কি চাই আচ্ছা আমি ওই জন্য ফোন করলাম একবার এবার আপনাকে ফোন করা হয় ও আচ্ছা আচ্ছা বাহ তাহলে তো আরামেই আছে মানে খালি বাড়িতে আছে না টাকা কামাচ্ছে আচ্ছা ঠিক আছে আপনাকে বলবো ঠিক আছে বলুন বলে এবারে যে যা বলেছে সব রেকর্ড করে যে এরকম আর এটাও লিখে দিল এটা গাড়ি ভাড়া গাড়ি ভাড়া দিয়ে দিতে বলেছে সেকেন্ড ওরা বলছে আমরা আর এই করতে চাই
বলছে না না আমি ব্যাপারটা এবার আমি দেখবো। ঘটনা চার্জ করলে আপনারা কি কি আপনারা হেল্প করেছেন ওনাদের কিভাবে অ্যাসিস্ট করেছেন আমাকে রিপোর্ট আর সেই রিপোর্ট যদি আমার পছন্দ না হয় আপনারা বলবেন আপনি কিছু পারিবারিক কোনো চিন্তা নেই আমি ফাইল করবো তাকে একটা পোস্টমর্টম আমি বললাম একবারে অনেক লম্বা টেনিওর থাকে না পুরে